Welcome. I'm Catherine Kennedy, Director of the Center for Tax Law and Employee Benefits at the UIC John Marshall Law School. The John Marshall Law School merged with the University of Illinois at Chicago last August and is now known as the UIC John Marshall. Our law school dean, Darby Dickerson, has moved us from a private law school to a public law school within a much larger university. As such, we are now the only public law school in the city of Chicago. We're also the only law school in the nation that offers benefits, that is, a Master's of Legal Letters in Employee Benefits for those individuals who have a JD degree. We offer over 20 employee benefit courses, ranging from the basics of employee benefits law to more advanced courses, such as ESOPs, international employee benefits, and ERISA litigation. As such, the Center for Tax Law and Employee Benefits is well positioned to provide educational forums for academics, practitioners, and human resource professionals. Our mission for the LLM program is fourfold. First, to offer graduate legal education with rigorous academic standards. Next, to foster legal research for a better understanding of the multidisciplinary aspects of this area of law. Third, to encourage student participation in appropriate bar and other employee benefits related professional associations. And last, to host educational forums where attorneys and employee benefit professionals and formulate solutions to controversial and timely employee benefit issues. To fulfill that fourth goal, the Center for Tax Law and Employee Benefits hosts an annual Employee Benefit Symposium. This year, our 16th annual Employee Benefit Symposium focuses on executive compensation. We'll begin by tracing its evolution since the passage of ERISA. We'll then talk about recent updates made to changes to the code section 162M and 4960, and we'll conclude with providing a discussion of the legal and practical challenges inherent in offering deferred comp and long-term incentive plans to executives within privately held companies. I'm delighted this year to co-host the 16th Annual Employee Benefit Symposium with the law firm of Winston and Strawn. This year's symposium features several of the partners of Winston and Strawn's Employee Benefits and Executive Compensation Department, as well as the Executive Compensation Practice Leader North America of the consulting firm Willis Towers Watson. I'll be moderating the first and third panels of the symposium, with my colleague Steve Flores, a partner at Winston, moderating the second. I will introduce the colleagues on our panel, but you have a much more robust description of their bios in your materials. I'd like to now turn the podium over to Joe Adams, a partner at Winston, to talk about his firm's Employee Benefits and Executive Compensation Department.
Thanks very much, Katie. Hope everyone can hear me okay. Welcome, everyone. On behalf of my colleagues, Ariane Andrade, Steve Flores, Mike Melbinger, and Ruth Weimer, and all of us really at Winston & Strawn, I'd like to welcome everyone to our presentation and thank you for joining. As Katie said, Katie asked me just to say a few words about our firm, and I'll keep those brief. Winston was founded in 1853, and it's one of the oldest law firms in Chicago. We have about 950 attorneys worldwide, spread across 15 offices, including a new strategic alliance in China. But more importantly for this audience, we have a very robust employee benefits and executive compensation practice. It's been recognized on a national level by Chambers, the Legal 500, U.S. News Best Lawyers, about 45 lawyers that focus exclusively on this area. So as Katie mentioned, it gives us a lot of breadth to delve into this, and you'll see this in today's presentation when Mike can give us this background on the history of exec comp, and Ariane and Ruth can give us their specific expertise on excise tax provisions, and then we'll talk about private company stuff. So I think it'll really show that breadth, and we'll also echo what Katie said about the multidisciplinary nature of this when you see all the tax and labor and corporate aspects that have to come into our practice. We are delighted to do this again with Katie, who's a fan. Many of us have known Katie for many, many years. Many of us started at the same firm many moons ago, and we've done this for several years now. And Katie always does a great job picking out different topics. Last year, I think we had some great welfare discussions with our partner Susan Nash. helping in those. So a broad range, and I think other years we did FLSA, right, Katie? So we've had some good discussions over the years, and we always look forward to this. And we're looking forward to today's presentation. We have a bunch of interesting topics we think you're going to enjoy. Before we start, I wanted to just cover off a couple of housekeeping issues. First, during the call, the participants will be in a listen-only mode to help with audio quality and bandwidth type issues. So keep that in mind, but we're certainly encouraging questions. We really highly welcome questions, and I personally, for myself, I love it when we get questions and we have interaction. So if you could type those questions in the Q&A box, that's one of the jobs of the moderators for each panel, is to try and look at those and see if we can work them into discussion. We won't share your name unless you ask us to, so feel free to do that. And then the second housekeeping item is with respect to CLE. We are offering CLE for this presentation. If you're interested in obtaining CLE credit, we have an electronic procedure to collect the documentation on attendance. Yesterday, you should have received an email that contains a link to an evaluation form, CLE evaluation form. As an initial note, when you open that evaluation form, don't be alarmed if you see that Mike Melpinger's evaluations are already completed. That's a requirement in Mike's standard appearance contract, so that's already done. But throughout the course of the presentation, we will be mentioning the presentation code. It'll both show on the screen, and we'll say it out loud for anyone who's participating on the phone. So you'll need to make a note of that CLE code and make sure and put it on your evaluation form. Once you submit that form back to us, we'll send you a certificate of attendance. You should have that by October 22nd. So with that, we're excited for today's presentation. We're looking forward to great presentations, great questions. So I think now I'm going to turn it back to Katie and Mike, who are going to lead us through the first panel.
Thanks a million, Joe. Yeah, I have the pleasure of introducing Mike Melpinger. Mike's a partner at the law firm of Winston and Strawn, head of the firm's employee benefit and executive compensation practice. He works extensively on designing and implementing stock and non-stock-based executive compensation and benefit programs for public and private companies. He designs and drafts employment contracts, severance agreements, parachute arrangements, and a variety of executive compensation arrangements. He advises boards of directors, compensation committees, and senior executives and legal departments in these matters. Mike's been recognized last year by Chambers, U.S. World Report Best Lawyers, and the Legal 500. Mike did his undergraduate education at the University of Notre Dame and his JD degree at the University of Illinois College of Law. Mike, the floor is all yours.
Thank you, Katie. As we know, and hopefully this is visible on your screen, we're going to talk about the evolution of executive comp since ERISA, more or less. But first, we'd like to ask a polling question to judge how many of you were around for ERISA and or the rest of the developments we're going to talk about. So please check one of these boxes, which should also be appearing on your screen. And I think we take about a minute for those questions to be answered. There's an old joke about how long a minute is, and it depends on a certain factor, but it may not be appropriate for younger listeners.
Yeah, the poll is closed. It's compiling. About a few more seconds here, we'll have our results.
I wasn't actually around with the firm when it was founded in 1853, despite my appearance in advanced age. But I need to clarify something Joe said. It is the oldest firm in Chicago, not just one of them. But I wasn't there at the start, I swear to God.
All right, Mike, the results are published and viewable. Can you see those? Yeah.
I'm having a little trouble getting it. Can you read them? I actually can't read them on my screen. I'm afraid to switch it because that'll screw it up.
Yeah, Mike, you've got 9 out of 45 for Part A, 7 out of 45 for Part B, 7 out of 45 for Part C, 10 out of 45 for Part D, and 11 out of 45 for Part E. So really pretty equal.
Okay, well, that's good. And maybe some of the newer folks in particular, or I guess the younger folks, this may sound like an old lawyer talking and those sort of old war stories, but a lot of these provisions we're going to talk about, in fact, all of them, you certainly have seen these provisions in the code or in documents, and heard them talked about and wondered why in the world or where in the world did that rule ever come from? And that's sort of what we're going to focus on today, how these rules came about and precisely when they came about and what they do. So with that, let's dive in. First, we're going to talk about 1970 to 1979. Now, I cheated a little bit here on 1972, which was, as you all know, before ERISA, because there was a very, very important feature of the accounting rules, not the law, but again, I'm going to fudge a little bit here because it is executive compensation. And that was Accounting Bulletin number 25. Now, what Accounting Opinion number 25 did was provided that if a company awarded a stock option to employees, the expense for accounting purposes would be measured on the day of the grant based on the difference between the exercise price and the price on the day of the grant, which is and was almost always zero. That is to say, the option was awarded at fair market value on that date, which meant there was no expense recorded for a company that awarded stock options from 1970, at least, until 2005, I believe. So we'll pick up on this point later, but that is a key component, or this was a key component in the sort of explosion of equity awards as a popular vehicle for compensating employees that began in the 90s and was really accelerated by the so-called dot-com bubble. Okay, then we have ERISA. Not much in ERISA really focused on executive comp, of course. However, it did add Code Section 415, which is limits on the benefits qualified plans could provide to employees. And boy, I can't honestly remember what the limits were back in those days. I remember them, excuse me, at many times over this time period, but not quite then. The point is, qualified plans could no longer provide the types of retirement benefits to higher compensated employees that they once could. So now we're beginning to see the introduction of non-qualified plans and the emphasis, or at least inclusion of other types of executive compensation. Now, in 1978, we saw the introduction of Code Section 401k, which was maybe the best development, one of the few actual positive developments on my entire presentation. I think you all know what 401k does, so I'm not going to repeat that, but it's relevant for executive compensation because it included limits on contributions in addition to 415, which again had the effect of limiting the amount highly compensated employees could defer. Again, facilitating the growth of non-qualified deferred compensation plans. So I'm thinking of non-qualified deferred compensation plans as executive comp and qualified plans not as deferred comp, but as benefits. Now, every executive, of course, ought to have the maximum qualified plan account or benefit that he or she can have under the code, because qualified plans are the last best tax vehicle in the world but they are severely limited in how much benefit can be provided to higher compensated employees. Okay, so now we move into the 80s. I started the practice of law on May 26, 1983. So I'm pretty familiar with this period. I wasn't around for MEPA, and I just sort of threw that in there for balancing out the graph in appearance, frankly. Then I threw in the Economic Recovery and Tax Act of 81. Now, what I used to have in here that it appears was removed, unfortunately, by the last revisions was a section that said recession, because a lot of the developments in executive comp and benefits, but mostly executive compensation, had to do with recessions or crises or scandals that had national effect, causing Congress to do something. And usually that something had more or less the opposite effect of what Congress intended, but nonetheless, that was a trigger. So you may recall at the end of the 80s, we had a fairly significant recession, malaise, I think it may have been called, that lasted through 1981 into about 1982, arguably 1983. But in 1982, we had TEFRA, the Tax Equity and Fiscal Responsibility Act, which added Code Section 416, top-heavy plan rules. Again, this is a rule that limited how much qualified plans could provide benefits to, in this case, top-heavy employees. Okay, so again, these developed as qualified plans are forcing more folks into non-qualified plans. And each development forces sort of a new group or a new company that maybe had not paid attention or had to pay attention to non-qualified plans in the past into one. Now we're starting to get exciting stuff. The Deficit Reduction Act of 1984, sometimes called DEFRA, added code sections 280G and 4999, the golden parachute rules. Now, interestingly, this is one of the first, or the first of the three huge unintended consequences I'm going to describe today. The golden parachute rules were added to the Internal Revenue Code because of a few notable, primarily a proxy fight at Bendix, I believe it was, in any event, where a company, and this is back in the days when companies did not want to be taken over, even at any premium price. So they put in like poison pills and poison pension payments and golden parachute agreements that provided essentially, okay, go ahead, take us over, but you're going to have to pay huge amounts to our executives, which would be a deterrent for providing these payments. So the Internal Revenue Code through Congress said, we're going to put a huge tax on golden parachute payments and prevent their deductibility under Code Section 4999. Okay, so what do you think happened next? Well, the word was spread that, hey, there's this new thing called a golden parachute agreement. And shortly after that time, very, very shortly after 1984, suddenly companies came to the conclusion, especially if their executives had a golden parachute, that maybe being taken over by another company wasn't so bad. Sure, you lost your job in many cases, but you received a huge golden parachute payment. So the effect of this change in the law was to make golden parachute agreements ubiquitous, essentially, at most public and many private companies. All companies in certain industries, such as financial services, which experienced a significant, I don't say culling of the herd, but combinations beginning in the mid to late 80s. You could not hire an executive in the financial services industry in the late 80s without offering him or her a parachute agreement. Okay, unintended. Congress didn't want more of these, but instead it caused them to increase 10 or 20-fold. Keep moving here. Tax Reform Act of 1986. before this, we worked off the Internal Revenue Code of 1954. So in case you wonder why, some of you younger folks, when you see the code defined as the Internal Revenue Code of 1986, you may think, well, duh, of course, what other code is there? Well, for old folks like us, there was the Internal Revenue Code of 1954. And we had a few years when I was young, which was 1984, poking fun at the older partners when they'd make a comment that may not have been exactly right. And you'd say to them, that must have been under the 54 code, right? Ha, ha, ha. Well, you had to be kind of secure in your position before you made that joke, but you can still use it now. Anyway, another couple very significant changes. The most significant being Code Section 401A-17, another limit on qualified plans. And I believe, I kind of forget, I think, was it $200,000, Katie, was the limit of compensation that was includable for qualified plan purposes under 401A-17 under TEFRA? Yeah, $200,000. Well, that, is not bad money, right? It's a pretty good amount, but again, and you had executives making $1 million or more, which means they weren't getting the full benefit of the 401k plan or the pension plan or the profit sharing plan or whatever kind of plan the company had. Boom, another explosion in non-qualified plan benefits. Also in 1986, you had a reduction in capital gains and ordinary income tax rates. What does that mean? Well, it means a couple things. When there's a reduction in capital gains rates, you have generally more equity compensation because equity compensation can qualify for capital gains rates. When you have lower income tax, ordinary income tax rates, often companies will say, okay, now's a good time to pay a lot of money. And that's what some companies did. All right, into the 90s. First big law, OBRA 93. This was a new administration, presidential administration. And one of the first things they did was pass OBRA 93, which made mostly these two very, very significant changes. First, they reduced the cap of 401A-17 all the way down to $150,000. Now, by 1983, it had been indexed upwards to, I believe, $235,800. It's either that or $238,500, but more than 200 and a lot more than 150. Okay, what was the effect? Exactly as I've described, more qualified plans. Suddenly, executives and management at companies who were making over $150,000, which, in 1993 was not bad money, but a lot of folks made more than that, thought about non-qualified plans again. And I hate to sound like a sort of a one-trick pony on this non-qualified plan thing, but anytime you can get benefits in a different way, these code sections have that effect. And I was a witness, and Katie certainly was, and I'm not sure if Don Delves, I'm not sure the others were old enough for 1993. Joe, I don't know, maybe Joe was. Anyway, the other big thing, and this was even bigger, the OBRA 93 added Code Section 162M, the $1 million cap on compensation paid by public companies to certain covered employees. Basically, covered employees being the top 5 executives, top 5 executives in policymaking positions at public companies. Okay, $1 million deductibility cap. Now, why do you suppose they did that? Well, they wanted to force companies to pay less money. Back in 93, there was screaming about executive compensation being too high, which we still hear today. But a very interesting part of 162M was the inclusion of the performance-based compensation exception. That is to say, the $1 million cap did not apply to performance-based compensation. The defined term was qualified performance-based compensation. Okay, well, what was that? For those of you who don't know, options, SIRs were automatically qualified performance-based compensation. Performance share awards, essentially restricted stock that vested or was awarded based on the achievement of performance goals. Annual incentive bonuses, all performance-based awards. Now, performance-based awards was a very good idea, and it did have that effect of forcing folks into performance-based compensation, probably before they ordinarily would have done so. But it also had two other effects. Number one is $1 million. Well, $1 million, by setting that as the limit, it kind of made it the, sort of like the opening stakes in poker. Now, any executive at a public company who didn't make $1 million in salary, couldn't even show up at the country club, for crying out loud, without hanging his or her head. So $1 million sort of became the standard. The other point was that, okay, it's sort of like an analogy to a diet. Suppose you're on a very strict diet, but your diet does not, and you're counting calories, but cheesecake does not count in your calorie counting. What do you think is going to happen? You're going to eat a lot of cheesecake. Well, if performance-based compensation doesn't count in the $1 million cap, guess what happens? Compensation, performance-based compensation goes way up. Okay, a lot of fun here. Unintended consequences. The next development was at the SEC's sort of rollout, creation of and rollout of the EDGAR, the Electronic Data Gathering Analysis and Retrieval System. That's what allows, not less so in 1994, of course, but nowadays, as you know, allows any 7-year-old with an internet connection to pull up the proxy filing of any public company in America and find out what the CEO, the CFO, and the other named executive officers were paid. All right, well, that's a really good idea, and it's had a lot of very positive effects that I'll talk about later. But one unintended consequence it had was to make compensation at every company fully transparent to, all viewers, to everybody, anybody with an internet connection. The effect of that really didn't begin to be felt until a little bit later, but the eventual result, and by the way, to make it clear, the IRS usually says things that companies cannot do, such as deduct compensation over $1 million. Whereas the SEC says you do whatever you want, but you have to report it, and you have to report it in a certain way on public filings. Okay, but you can pay whatever you want. So the idea of EDGAR and of all the rules since then passed by the SEC is sunshine is the best disinfectant, right? You've heard that. I think Felix Frankfurter was the first one who said that. Maybe not, maybe, I don't know. Anyway, the point is you do whatever you want, but you have to disclose it to your shareholders, and then we'll let them put the pressure on you. But skipping ahead to the punchline for this, the development of EDGAR and reporting is that suddenly every executive compensation lawyer, every executive compensation consultant, and every executive in the United States could troll around on EDGAR and figure out what other executives were making. Not to mention the press, of course. The press could go in there and describe in great detail what executives were making. Well, again, what do you think happened? Executives would call up Melbinger with their new contract and say, hey, I want one of them there golden parachutes, and I also want a SERP. And what's this, a perquisite that allows me to get free doggy daycare? I want that too. I'm exaggerating perhaps a little bit, but I think you get the idea. So again, another unintended consequences. Now that's the big three for unintended consequences. 162M, 280G, and EDGAR / public disclosure. So you don't have to listen to me talk about that anymore. Then, of course, we had the burst of the dot-com bubble, which also included significant accounting scandals, including the demise of Arthur Andersen, a market crash, and the beginning of a recession. What does that mean? Everybody, not at once? Ha, you're all muted. Anyway, what it means is Congress does something. They do something quickly, and it usually is fairly ham-fisted. They usually take an anvil to kill a fly, and therefore there's more unintended consequences. Well, the first thing they did was actually not so bad. they passed the Economic Growth and Tax Reconciliation Act of 2001, so became known as EGTRA. EGTRA, excuse me, increased the 401k limits and reduced the ordinary income tax limits. I don't have to repeat again what the effects were of those were, but generally positive. But the big one was the Sarbanes-Oxley Act of 2002, which was passed in response really to the scandals, particularly the accounting scandals. And as you may recall, if you were around then, Sarbanes-Oxley, or SOX, imposed significant new rules, obligations, and liabilities on audit committee members. Audit committee members of boards of directors of public companies, not private, which is important because Sarbanes-Oxley was the first sort of the peak of companies going public. Sarbanes-Oxley led to a decline in companies going public because the rules suddenly were much more burdensome and compliance was much more costly. But there were some provisions in Sarbanes-Oxley that had a direct impact on compensation. First of all, this is the first appearance of compensation clawbacks. That was fairly narrow. It only applied to the CEO and the CFO, but the SEC has had more than a dozen enforcement actions over the years, dozens, I should say, under Sarbanes-Oxley, because the Dodd-Frank rule, which we'll talk about in the last slide, isn't effective yet. They didn't publish final rules. So this is the only clawback provision effective unless, of course, it's voluntary by the company. It also, SOX, prohibited loans to executives, which you probably have never seen nowadays at a public company, and that's because they're prohibited. But in the old days, it became, around this time in the late 90s, it became very popular for companies to lend huge amounts of money to their executives, who then bought company stock, which then rose up. Well, until it didn't rise up anymore with the market crash, and tragedy ensued. Section 16A filing deadlines. 16A is the section of the Securities and Exchange Act that requires companies to file within 2 business days a Form 4 for any acquisition or disposition of stock. Okay, whether it's inside the market or from the company. Now hold that thought for a minute because I'm going to come back to that later. Pension fund blackout rules not really affect on executive comp. CEO, CFO certification, that's more in the nature of, burdens that were imposed on public companies. Okay, moving right along into 2003, we had the Jobs and Growth Tax Relief Reconciliation Act. That one didn't really have a snappy acronym that I can remember, but it reduced tax rates on dividends and capital gains, which means we got more dividends and more equity compensation purchases, transactions, right? Which both EGTRA and the Jobs Creation Act were attempted, not creation, that's coming later. Jobs Growth Act were intended to sort of boost the economy, which they essentially did. But we've got one more big piece of legislation coming in response to the scandals of the dot-com era, and that was the American Jobs Creation Act of 2004, which added the infamous Code Section 409A. And I probably should have had a trigger warning in there because the mere utterance of the phrase 409A still makes me shake a little bit and may have that same effect to you, which the effect of it, of course, for those who weren't around then, is it turned the entire world of non-qualified plans and employment agreements, severance agreements, and to a limited extent, equity compensation arrangements on its head. Okay, it was a completely new set of rules. And that's good for newer people because you got to learn the new rules. Forget about all the crazy old rules that Katie and Mike had to learn when they were young pups. Which, by the way, when Katie and I started, we were only 14 at the time. So it may seem a long time ago, but we were precocious, I guess. Okay, I don't have to talk anymore about 409A because I think we're all still see the effects of that today. But now I'm on to FAS 123R, 2005. Now, this is the rule accounting rule that took away the favorable accounting treatment for stock options. So in 2006 and after, companies that awarded stock options had to reflect an accounting expense. Now, what that did was level the playing field between things like restricted stock, performance shares, RSUs, that used to be accounted for differently than options and SARs. Suddenly, there was a level playing field, which hugely accelerated the push toward RSUs and restricted stock and performance shares, right? We already had that push for performance-based compensation. And just a bit of a regression. I recall seeing in the front page of the Wall Street Journal, and I can't remember the year anymore, but it might have been like 1996. For some reason, that stands in my mind. Front page, Bank of America awards stock options to 100,000 employees. Why wouldn't it? No accounting expense. You don't have an accounting expense. You don't have to expend cash. That's, of course, what all the dot-coms did, but it even spread into the larger companies. And at this time, everybody, every executive, every working person knew what stock options were, because if you walked to your back fence and told your neighbor, hey, I'm looking at a new position, the neighbor would say, well, I just took a new job and I got some of them, their stock options. How about you, George? Well, if you didn't get stock options, you had to go and hide your head in shame again. Prior to that date, well, and maybe earlier into the 90s, I really don't think many of us knew what a stock option was, except for senior executives and board members and, and true compensation lawyers. Okay, so we saw an explosion in equity compensation that was due to factors, well, that I just described. Okay, stock option backdating scandal. Think back to the section 16A filing requirements. Well, it seemed that some companies, primarily in the West Coast, thought that it might be okay to award stock options to executives at the lowest price of the stock on the entire year. Okay, so they'd sit around here in November, December, October, whatever the month was, and say, well, gee, we had a real downturn in our stock back in March. It hit $12 a share. Now it's at 25. Let's award options at $12 and pretend they were awarded on that date. Now, how anybody could have thought that was, how any lawyer could have thought that was okay is beyond me. But they did it, and it was a huge scandal. And it was a scandal because Section 16A suddenly required these filings within 2 business days. You could no longer backdate options. All right, well, it took a little while for the word to get out, but once it's out, you don't see option backdating very often anymore. Then we had the most significant change in the securities disclosures laws here. And I give the release number, but it happened in 2006, and it added it added what I have listed here. I don't have to read all these things. The CD&A, the summary compensation table, the disclosure of perquisites, disclosure of retirement benefits, disclosure of payments made on termination or change in control. What we saw, for example, is before this period of time, in the early 2000s, a company would be acquired, and eventually word would get out to the press, not really to the press, but there'd be a public filing after the acquisition that the CEO of the acquired company would be leaving, but he or she would get a parachute payment of, I remember one, $240 million. That's not bad money, even for 2006. So that tends to shock the conscience of readers and Congress. And what really shocked them is not even so much the amount, but that nobody knew. Okay, the same thing for retirement, non-qualified plan benefits, pension benefits, and SERPs. They weren't disclosed. So you could have an executive, and Dick Grasso, the former head of the New York Stock Exchange, was the actual person that led to the SERPs being a disclosure requirement because he had something like $139 million in his SERP. So his disclosed compensation wasn't really that high. And by the way, this was, there was nothing nothing improper about this except maybe the amount and the lack of disclosure. When that came out, people hit the roof, and suddenly everybody knew, including Congress, about this thing called a SERP. And these things called non-qualified deferred compensation accounts, which had been building up because of all the prior laws. And then lastly, summary compensation table. Recall that lists all compensation, kind of often overvaluing equity awards with a single column at the end listing total compensation. Well, now the media will quickly flip to any proxy and go right to the summary compensation table, right to the last column that says total compensation and report it in the press because it's usually often a pretty big number. I mentioned perquisites. I don't want to go without perquisites because the one positive, very positive, that is if you're a good governance type or an investor of this disclosure, and these were all really disclosures because again, people have asked, the media always asks me this, why can't we control compensation? And I say, the rules since 2006 actually have controlled compensation. Yes, it's going up, but it's going up in a way that's fully public. And we got rid of all these things like perks we didn't get rid of perks and SERPs, but now they're disclosed and the amounts have gone way down. Okay, no one anymore flies their corporate executives to the Masters golf tournament in Augusta, Georgia on the company private plane and puts them in a house for free. Okay, because that was reported in the front page of Section B of the Wall Street Journal consecutively for several years. Gradually, no one did it anymore. Now, they were still paid a lot of money, but some of the, what you arguably could call abusive arrangements were done away with. I might be getting a little behind time, so let me pick up the pace. Okay, I think you all recall that in 2008, 9, 10, we had a fairly significant market crash, I'm told, and a fairly significant recession. So what did Congress do? They acted. They did things. They did a bunch of things. Number one, they passed ERISA and ERA, which included TARP. Now, if you didn't take TARP money, and these were mostly financial institutions, of course, and if you didn't take TARP money, you didn't have to comply with ERISA and TARP and ERA. But what these states did was rolled out things that later appeared in the Dodd-Frank Act. So I'm not going to describe what they did, but if you're paying attention, this was sort of a preview of them. And I say this because, when you look at legislation and you see it's opposed by it's proposed by the minority party, maybe you think, well, that has no chance of passing. I don't have to pay attention to that. Well, what happens is legislation like that goes into somebody's best back pocket. And a few years later, when the presidency changes, all that stuff comes out of the back pocket and gets in the next piece of legislation. And that's what happened in 2010. First, I'm going to talk about SEC risk disclosures. That was another result of the perception, probably right, that the compensation programs of financial institutions, primarily financial institutions, incentivized executives to take huge risks, get their money, and then leave, right? You make all these loans to people that can never repay them, you collect your commissions, and then you leave. And then when the defaults come, you're gone. You're two banks being employed by two different banks since then. Anyway, the point is there was some merit to that, and it was another positive development in the securities laws. Finally, 2010 to 2020, the present era, sort of. Okay, first thing, Dodd-Frank Act. Congress, in bipartisan legislation, by the way, as was the Sarbanes-Oxley Act. There's less partisanship when there's a crisis and a scandal, particularly. Like there must have been a scandal to cause the market crash. The Dodd-Frank Act, some people have referred to it as the Sarbanes-Oxley Act for the Compensation Committee. That is, Sarbanes-Oxley was all about the audit committee. Dodd-Frank is not all, but largely about the compensation committee. Okay, I'm not going to read all these things, but the Dodd-Frank Act made 11 different changes to the area of executive compensation. Interestingly, all of these changes were phrased, in the law say that the SEC shall pass rules prohibiting the listing of a public company unless it has a compensation clawback policy, for example. Okay, well now, 10 years later, the SEC has not published final rules on the listing standards for public companies or the requirements for a clawback policy, which means that section is just not effective. Now, nearly every company in America has a clawback policy because it's the best practice, but that was a unique feature of the Dodd-Frank Act. The other of these provisions, of course, have had effects. Shareholders say on pay. That was another one that hopefully you know what that is, but it gives shareholders a right to vote every year on the pay of the named executive officers. That had a real effect on compensation. You could argue maybe it still seems to be going up, but again, a lot of abusive stuff has gone. You no longer see huge payouts upon a termination for cause, for example, like in the Me Too era. Now you saw a few that slipped past, but what are you seeing? You're seeing litigation because they shouldn't have been paid. Things like that. Again, some abusive arrangements. Back before this, we had something called you had like golden coffins. Okay, one CEO had what they called a golden coffin. That when he died, his family got $100 million. Hard to know why that really was, but once it came out in disclosure, shareholders voted against the board and against the shareholder say on pay, and gradually reform came about. So there really has been significant reforms in compensation. They just haven't quite reduced the overall total amount. Okay, last two, the Jobs Act of 2012. This was a small effect, but it basically created this new category called emerging growth companies, EGCs, that had fewer reporting rules, fewer requirements for annual reporting, right? This is kind of a belated reaction to the Sarbanes-Oxley Act, which had caused a number of public companies to go way, way down. Positive, not dramatic for executive compensation, but most of these emerging growth companies were startups, and that's where a lot of the executive comp issues can arise. And now here's where we are sort of today, because our most recent law was the Tax Cuts and Jobs Act of 2017, which made some very significant changes that are hitting us, I don't want to say too hard, but they've had a significant effect. First, well, most of them relate to 162M, right? It eliminated the performance-based compensation of 162M, which now makes that $1 million cap pretty much a hard cap. There is virtually no way around it. We have a couple ways you can kind of nibble around the edges, but you can't get millions and millions of dollars deductible under the performance-based compensation exception. Now, what is the effect bit of that? Nothing so far. Companies, because it applies to everybody, companies have said, well, if nobody can deduct compensation, we're all at the same disadvantage, and we're not going to cut our executives' compensation to $1 million because they'll all leave. So there you have it. Well, that's where we stand today. Maybe there'll be some effect later. They also extended this statute, 162M, to other officers who were not previously covered employees in a couple different ways, such as the once a covered employee, always a covered employee, all the way till death rule. Swept a whole bunch more people in there. Also swept in more companies. Some private companies that do limited SEC reporting are now counted as public. And lastly, again, it lowered capital gains and ordinary income tax rates. Now, why I'm emphasizing this as the last point of the presentation, because one might conclude there's a pretty decent chance that capital gains and ordinary income tax rates will go up next year. So harken back to 2017, December 2017, when everyone knew the tax rates were going to be lower in 2018. What happened is companies attempted to postpone payments into the next year so executives would be taxed at a lower rate. And also, if they could, accelerate deductions into 2017 when they were worth more because tax rates were higher. So what are we going to see if rates are increased in 2021? Well, get ready for action in December, not December of this year, but December of 2021, where the opposite will occur. Companies will want to postpone the deductions. Executives will want to get paid more in 2021, if at all possible. So what's going to happen in the future? Well, that's what's going to happen next for many of us on the phone, the next predictable event, but also some of these things you've heard talked about, legislation proposed by Bernie Sanders. They may have thought, well, that has no chance of passing. It'll pass maybe in the House, but it won't pass in the Senate. The president certainly won't sign it. Well, go back and find those bills because they might get loaded into an omnibus bill or some other kind of bill now, and they just might pass, assuming there's a change in presidential administration in 2021, 2, 3, or 4. Okay, that's the end of it for today, and I guess we'll now take some questions. Katie?
Thanks, Mike. That's terrific. So I've got a couple of questions. Shareholder groups such as ISS have had more of an impact on executive comp than any other stakeholder. Do you think that they actually have too much say in the area of executive comp? And over the upcoming years, do you think these groups will continue to be more powerful, at least for publicly owned companies, and their pay practices become the primary drive in the area of executive comp?
Well, that's a good question because we're at an inflection point right now. Answering the first part of the question, I personally believe, and nearly all my clients believe, that ISS and Glass Lewis have acquired far too much power in the influence of proxy voting. And the reason for that is many companies accept their recommendations, but they're not governed by anybody. They just come up with these policies on their own. And, you might say, well, who died and left you in charge of saying what best practices are? And it's not just compensation or corporate governance, but at things like climate change and ESG. Now, you may think those are great ideas, by the way, climate change, ESG, they ought to be changed. But who should decide that? Should it be ISS deciding it for the rest of the market? I don't think so. However, what we had in 2020 was SEC final rules that put some new burdens on the proxy voting advisory businesses. ISS and Glass Lewis, by the way, have something like 97% of the market. So they're the only two we really have to mention. Anyway, they won't be effective until 2021. And there's a lawsuit ongoing filed by ISS against the SEC, saying it violated certain rulemaking procedures, which I'm not that familiar with the technicalities, so I can't say for sure who's going to win that. And again, if we have a new administration, they may change the rules. They may repropose rules. So there's the two halves of the answer to that question. I think they had too much power. It may or may not be cut back. Now, I'm sorry, let me say one more thing. Now, best practices which have developed since the disclosure rules came out, truly a lot of these things are best practices, and I support 90% of them, if not more. The fact that you had ISS to use as a club, and I hate to say this, but having the push of ISS was more than just Melbinger or Don Delves or Joe Adams saying, boy, you really ought to limit your golden parachutes to 2 times or 3 times pay instead of 6 times pay. That's getting out there, and ISS is going to vote against it. So their influence hasn't been, well, I don't object to all of their influence. Let's just say that.
Okay. What changes do you think will be made to Sarbanes-Oxley or can you make some predictions?
I'm sorry, that one kind of went in and out.
Oh, sorry. can you make some predictions as to what future changes will be made to Sarbanes-Oxley and or to Dodd?
Well, I think we'll finally have the compensation clawback rules be finalized. But as I said, certain bits of legislation that came up, for an example, specifically something that was proposed by Bernie Sanders, and I think it was approved by the House of Representatives, despite my not paying that much attention to it. It kind of went into the back of my mind, was a bill that would eliminate the deduction for stock options. Well, I'm not sure why that is, but some folks in Congress have decided that stock options are bad. And there's arguments to be made against stock options in every type of compensation. But I wouldn't be surprised if that resurfaces, again, assuming there's a change in presidential administrations, that's the kind of thing that surfaces. We also had, one part of Dodd-Frank that probably never will see SEC regulations is these rules on risk-taking by financial institutions. It's the third to last bullet point here. Those rules they were complicated and unwieldy, but they would have imposed things like mandatory compensation deferral on financial institutions. Again, to avoid this thing where you had executives who did bad things or made bad loans, jacked up their compensation, and then left. There would have been literally a mandatory deferral of compensation for something like 7 years, up to 7 years, and then a mandatory clawbacks for up to 10 years. The rules were proposed in 2011, and they were re-proposed in 2015. And both times I wrote a comment letter and met with government officials on behalf of clients in our comment letter. And both times Congress decided, the agencies decided it was just too complicated and it wasn't ready for prime time. But there were some tidbits in there, and this is going back to what I said about TARP, ERISA, and ERA, the legislation that came out against financial institutions or applicable to financial institutions in 08, 09. Things like that are often a preview of things to come.
Exactly.
Yeah. So again, there's all these things that have happened, and the only thing I can think of good about being old is that you've seen all this stuff. You remember where it came from, but young people too can remember these things that happened 5, 6, 7, 8, 10 years ago, and put in the back of their mind is something that just might come back in the future.
Okay, got another question here. If there is no major executive comp legislation coming up, what influence do the federal agencies have to influence executive comp?
Well, if it's not the IRS, the SEC, of course, is really the one that's had the most effect. As I said about IRS,
yeah,
most of what they've done has had the opposite effect of what they intended.
right.
Whereas the SEC has followed the policy of you pay whatever you want, you just have to disclose it. And then they've let the marketplace do the heavy lifting. And 10, 15 years ago, the big investment, 20 years ago, the big money holders like the institutional investors, BlackRock and Fidelity and Vanguard, who collectively hold huge amounts, unbelievable amounts of company stock, and therefore vote incredibly large portions of proxies every year. Yeah, they just kind of voted with management. Well, now they've all, like ISS, published their own voting guidelines. In fact, folks like BlackRock and State Street, I believe, have taken sort of a lead role in demanding gender diversity on the board and eliminating a gender pay gap and climate change disclosure. And before that, it was compensation clawbacks. So the disclosure rules are having that significant effect. And those are really done through shareholder proposals. So that I frankly see, absent major legislation, that's where I see the changes coming from. And I tell you, I would bet if there's a change in administration, I will bet we'll have mandatory ESG disclosure rules in 2021, because we first had the human capital management disclosure rules proposed and discussed in 2019, and they were just finalized in August of 2020. So I think the SEC is kind of rolling these things out one after another. And I dare say the rules will be different under an SEC commissioner appointed by a Democrat than they were or would have been under a Republican. You know, that I'm not trying to take a political position. I think we just all recognize that. And it may not be a bad thing, right? ESG, maybe that's a very, very good thing. But it's a fact of life that we'll probably see, or we may see in 2021.
Another question, what impact the COVID pandemic having on executive compensation plans and 409A? Do you think Congress will provide any relief for the distribution rules in 409 Cap A?
First of all, I only recently heard about this. We had a grandbaby born earlier in the year, and I just haven't been keeping up with the news. But I guess there was something that happened. But okay, it's kind of a multi-part answer. First of all, literally hundreds of companies have reported, and probably 1,000+ companies have undertaken a change in their performance metrics due to the pandemic. And we've kind of kept a chart of the companies that have reported their changes publicly. Not all companies have to report their changes, depending on what those changes were. And including many of our clients. Anyway, but they're doing things like splitting the 2020 into two. So you got two 6-month performance periods, one of which is more or less written off because it won't pay anything. But the second one still has an opportunity to pay. Or for some companies, the first one has an opportunity to pay, depending on what their fiscal year is. And then you've got just readjusting the performance targets. So that is happening and will continue to happen well into December, when compensation committees sit down and say, well, what kind of bonus should we pay for 2020? Now the stocks, right? Stocks have mostly recovered, not all, of course. Some have done great, some have continued to do very badly and even gone bankrupt. But the main body will have these adjustments. So now we're going to go into the proxy season in 2021, and all these adjustments are going to be disclosed to shareholders. ISS says that it understands there's going to be adjustments. So it won't be as bad if they would have, in just a normal year, companies would have made an in-flight adjustment of performance goals. But it's going to be, there's going to be a lot of serious and hard conversations that come with ISS and others, the other institutional investors, about these changes. Could you repeat the second half of the question?
Do you think Congress will provide relief in the distribution rules under 409A, similar to what they've done under a qualified plan?
I was told there'd be no math on this webcast. Distributions, I guess, you're talking about qualified plans, right?
Right. Well, they did provide some relief for qualified plans. Do you see some kind of relief for 409A?
409A, I'm sorry. I should have been listening more closely. I just started thinking about math and it shut me down. Good question. They have made some modest adjustments to the 409A rules that allowed for easier hardship withdrawals, much easier hardship withdrawals, which were very, very hard. Honestly, the way the stock market has recovered, right? I mean, it's back to like 28,000. I'm not sure they're going to do that. I'm not confident they're going to do that. The problem is, what we might see, a lot of companies, as everybody knows this, have gone into bankruptcy. And a lot of those companies have had very significant deferred compensation amounts and SERPs, right? Particularly, we have quite an active oil and gas practice. And those companies have been hit very, very hard. The airlines have been hit hard before, right? So that's not a big surprise. Oil and gas hit very hard. And these folks, that's a lot of money. Imagine saving for 20 years and having it wiped out. I wouldn't be surprised to see some changes made in reaction to that. I don't know what they're going to be, frankly, because 409A prohibits us or limits us from the type of funding we're going to make. But when constituents, also known as voters, lots of money, sometimes they call the congressperson.
And then one last question. I agree with you that I think Congress has used to try to curb executive comp, and it's all backfired on them. Do you think they're done with using the code to curb executive comp, or do you think they'll still come at it?
Oh, no, they're definitely going to still come at it. There was one proposal after the financial crisis to impose a 95% tax on the bonuses of executives of financial institutions.
Oh, wow.
And I appeared on national TV several times on behalf of certain clients that didn't want to appear themselves. So I was the one up there saying, oh, no, this would be a bad idea. And honestly, what I said at the time is, this was back then, the Yankees were in the World Series, and CC Sabathia, I think, was their pitcher. And I said, you know what? Here's a picture of the Yankees pay $33 million a year. Now, I'll bet you, the point was supply and demand. I'll bet you that if you suddenly said he's available next year, there'd be a lot of teams that would pay him $33 million a year. So you have to understand, Congress, or viewers in this case, constituents, that it's supply and demand, right? Nobody forces these companies to pay executives 10, 20, $30 million. They do it because that's what the market says. However, you'll note that no politician of either party has ever been criticized for bashing executives or executive compensation, right? Neither party. It's a very popular bashing topic. So anything that comes up, and again, I keep referring back to the Bernie Sanders thing, because to me, it doesn't make a lot of sense. And you might think, well, again, forgive me if this is political, but you might think, well, Bernie's kind of a fringe guy. Actually, not really with the number of votes he got. But the point is, well, guess what? This is bashing executives. It's got to be good. Who wants to vote against that? So yes, they was gonna, I would bet my life they're going to keep futzing with executive comp. That was futzing, by the way, to be clear, not.
So I take it your attorney would be to go into executive compensation?
Yes, definitely. I would definitely say go into executive compensation, because despite everything I said, our clients like us, right? Because first of all, they're not in litigation. So there's not a winner and a loser. They don't lose a case. They don't win a case and have to recover $1 million, but have to pay $800,000 in legal fees. No, they call Mike, and Mike says, here's more stock options. You want a better golden parachute? Let's do that. So executives like us, it makes your days a lot happier. And all these laws, right? Every time they pass a new law, what does that mean? It means we have to redo everything. And I'm sorry to be, I don't know if this is Machiavellian or cynical, but it's the way of the world, and Congress isn't going to stop, and the SEC isn't going to stop. So it's job security, perhaps.
And Mike, one last question I meant to ask you. What are the issues right now that you see in executive comp litigation?
Well, you know, it's funny, because after I finalized the PowerPoint, I thought, you know what, I should have put a little bit of case law in there. Case law, the courts have not had a very significant effect on compensation, except to sort of wave it through the gate. We had the Disney case. If this is back in, oh God, the case was decided in 2005. I think the incident was in the late 90s. You know, they hired an executive. He was employed for less than a year. Michael Ovitz went to another job where they paid him even more, but Disney paid him $100 million plus in severance. How could that be? Well, that's what his contract paid. And so that led to a lawsuit, and the lawsuit basically said breach of fiduciary duty for paying this much to somebody who terminated on his own voluntarily, and waste of corporate assets. Well, it went to the Delaware courts, and it went 3 steps up all the way to the Delaware Supreme Court, and they said, well, in fact, my blog title at the time was Delaware Court holds its nose, but approves the Disney board's actions. They were very critical of it, but there was no violation. So that was sort of like, okay, Katie, bar the door, pay whatever you want because the courts aren't going to take a role here. That has evolved, and even some of the Delaware justices back at the time were saying, I don't know so much about this. Maybe in the future, different standards will arise. And that quote came out of the Disney decision in 2005, I believe. Since then, the head of the Delaware Supreme Court has resigned, took senior status and went to work for a law firm, and now he's writing papers about reducing compensation and stakeholder capitalism. So the courts are kind of evolving here. So we've seen two types of legislation. The ones that have really gained traction are lawsuits against directors for executive compensation. That's a bit of a drafting area that I think most have corrected, but it has had a significant effect. Directors' compensation has gone down. It's been rationalized, and it's now reported in much greater detail. Since these lawsuits began in 2012, it's the first time we started writing about them, but they continue today. People aren't just, boards must not be reading this stuff. But also there have been some more recent lawsuits kind of going back to the Disney well, saying, all right, this is a breach of fiduciary duty or corporate waste, including one against Tesla and Elon Musk. And whatever you think about them, they're paying him a lot of money. And he already owns a lot of shares. And I think at some point, the Delaware courts will say, enough is enough, or enough is too much. Now, that and $3 will get you a cup of coffee at Starbucks, but that's my opinion.
Well, thanks, Mike. This is a terrific panel, very, very informative. And I'm sure viewers will appreciate getting the historic being able to figure out why we are where we are. So
very good. Thanks all.
Thank you.
So I'm Steve Flores. I'm a partner here in the Employee Benefits Executive Compensation Group at Winston and Strawn. Welcome to the second panel of this afternoon. We're going to be discussing an update on recent changes to Section 162M and 4960 of the Internal Revenue Code. I am thrilled to introduce today's speakers. We have Ruth Weimer and Ariane Andrade. Ruth is a partner here at Winston & Strawn. In addition to being an attorney, Ruth is a certified public accountant with nearly 30 years of experience, previously serving as a senior partner in a national tax department of a Big Four accounting firm. She focuses her practice on matters related to executive compensation, including international matters, employment taxes, payroll taxes, fringe benefits, the personal use of business aircraft, and qualified and non-qualified deferred compensation. Ariane Andrade is a senior associate here at Winston. Ariane focuses her practice on a broad range of employee benefits and executive compensation matters, really concentrating primarily on public company executive compensation arrangements and disclosures, as well as employee benefits aspects of mergers and acquisitions, and qualified and non-qualified retirement plans. So as we did with the prior panel, we have a Q&A. So please, if you have questions, ask them and try to get through them. But we have a lot to cover, so we may not get to them. If we don't, we will follow up with you after the fact. So we're going to jump into the presentation, but after the presentation is over, we will provide you with CLE information, the code that Joe mentioned at the beginning of the presentation. So let's go ahead and get started. Ariane, can you kick us off? Discuss a little bit about the comparisons between 162M and 4960. There's seem to be similarities and similar kind of policy objectives, but for different types of organizations.
Yep. Thanks for the intro, Steve. So I'll kick us off here, as Steve indicated, just going through a really high-level comparison of code sections 162M and 4960. The changes to section 162M and the implementation of code section 4960 both came out of the Tax Cuts and Jobs Act, which was enacted late in 2017. And both code sections became effective for the first taxable year beginning on or after December 31st, 2017. Both code sections limit the deductions that employers can take or impose penalties on employers that relate to executive compensation. While 162M applies to public companies that are not tax exempt, 4960 applies key features of Section 162M and also Code Section 280G, as we'll discuss a bit later, to tax exempt organizations. While 162M provides that compensation paid to a covered employee in a taxable year in excess of $1 million will not be deductible to the employer because of the elimination of the performance-based compensation exception, which used to allow for a deduction of certain amounts over $1 million. 4960 imposes an excise tax of 21% on the employer, not the employee, with respect to remuneration that exceeds $1 million, and also imposes an excise tax on excess parachute payments that are made in connection with the termination of employment. Both these code sections apply to the compensation that's paid to an entity's covered employees. In the 162M context, this includes the CEO, the CFO, and the top 3 highest paid executive officers. For Section 4960, this means the top 5 highest paid employees of the organization with certain exclusions. Under both provisions, once someone becomes a covered employee, he or she is a covered employee effectively until death. And then finally, both 4960 and 162M include a grandfathering concept, which means that certain amounts or contracts that were in place before the implementation of the Tax Cuts and Jobs Act may be eligible for continued applicability of the old rules, or in the case of 4960, certain amounts are excluded from the application of the excise tax, assuming that the applicable requirements are met. So now I'll pass the baton on to Ruth, who will talk about 162M in greater detail.
Thank you, Ariane. Okay, to pique everyone's interest, as Ariane discussed, we're going to talk about 2 different code sections and big changes that were made. And I'm going to cover the 162M changes that apply only to public companies. And Ariane is going to cover the 4960 excise tax that applies to tax-exempt organizations. So in the audience out there, those of you who only work with tax-exempt organizations might say, I'm going to shut Ruth Weimer off. I don't want to listen to her. Or vice versa. If you only work with public companies, you might say, I'm not going to listen to Ariane. Oh, that's not something I deal with. And then finally, those of you who only work with non-public and non-tax exempt might say, I'm just going to go eat my lunch right now while this 1-hour discussion is going on. Well, you can't. You have to pay attention. Why? Because the companies that are covered by 162M include everyone in the affiliated group, and the companies that are subject to the excise tax, which Ariane is going to discuss, will also include all the members of an affiliated group. The members of the affiliated group can be partnerships, they can be S corporations, all kinds of companies. So listen carefully, because what we're talking about may affect your clients or the company that you work for, no matter what its character. Okay, I've been around the tax world of compensation for many years. I think Mike beats me by just a few. And Steve's overview of my background, unfortunately, I didn't update it. I blew past 30 years some time ago. So that kind of dates me. But when 162M was enacted, which I view as relatively recent based on my long career, I actually thought it's not the worst thing in the world, because what it was doing is trying to manipulate behavior by denying a deduction for compensation paid over $1 million to covered employees by a public company. And what fascinates me, I've been in the tax world for a long time, and in law school, when I took my first tax course, I just absolutely fell in love with tax law because it's highly technical. And what's interesting, though, it's not just let's see how much revenue we can get from individuals and companies. It's very social policy goal driven. And I think Mike was kind of referring to that, like, let's beat up the executives and deny deductions for their compensation, and that will manipulate behavior. Well, it was a great idea when 162M was first enacted, but unfortunately, way back then, they had, as part of the statutory provisions, a loophole, if you will, that was so huge you could drive a truck through it, or you could drive $50 million through it, and that was performance-based compensation. All a company had to do was play the game of performance-based comp, have the shareholders approve a plan that described how much could be paid as performance-based comp in the form of shares or cash, and then set up a performance goal, which, quite frankly, might not be so difficult to meet. The regs even said if there is revenue, that revenue is not a performance goal, but income is. So you could say, if our income is the same as last year, you met your performance goal. So again, it used to be just a little too easy to get around, not very effective. Now with the changes, as Mike gave a heads up, more companies are subject to 162M. The change was that not just public companies filing under Section 12, but any companies that needed to file reports under Section 15D of the Securities and Exchange Act. Section 162M now applies to the CFO. That's one of the changes made by Tax Cuts and Jobs Act. The category of covered employees, which have their compensation limited, has been greatly expanded. Also, as part of the change, once a covered employee, always a covered employee. The Tax Cuts and Jobs Act amended 162M to provide that any individual is treated as covered under the new rules would continue to be considered covered, not only until they died, but actually even after their death. Anytime compensation was paid with respect to that individual, it would be subject to these limits. Now, what I did is make up a flow chart that would allow companies to analyze what amount of compensation would be deductible after the Tax Cuts and Jobs Act. If you can get your way through this flow chart and to the bottom line, you'll know what the total dollar amount is. The problem is that some of the terminology and definitions as you go through this chart are very, very detailed. The proposed regs give us some of the rules and some examples, and it's actually quite difficult to know whether you can pass down that black arrow down to the very bottom. First, you need to make the analysis of whether the employee is working for a public company. And as I said a few minutes ago, the public company includes members of the control group. Public companies can include any company, even foreign reporting companies, and those trading with ADRs and S corporations and partnerships with public debt, just a whole slew of different kinds of companies. And so now that takes much more analysis to determine whether you're at number one and are an employee of a public company. So let's suppose if you go to the bottom and you're in the nirvana of being able to deduct compensation over $1 million. But remember, if you are a Cody It doesn't mean just because you got past 162M, you can deduct compensation over $1 million. It's got to be reasonable comp. So you can't, the Internal Revenue Code doesn't allow deductions of excess compensation, even if below $1 million and even if by a non-public company. Okay, the next step would be, is it a covered employee under the new law, which is a PFO, or formerly a covered employee under old law in 2017 or new law in 2018 or thereafter? And you might say, what is that all about? Well, the law was passed effective generally for 2018. So in implying once a covered employee, always a covered employee, you look at the status of a person in 2017, and there, if the person was a CFO, that doesn't put him in the category of always a covered employee. But if he was one of the 3 highest paid or CEO, yeah, he's tainted forever. And then starting in 2018, it's the CEO, CFO, and the 3 highest paid employees anytime during the year. So let's suppose they are, you have to keep going. If they're not, shoot down to the bottom, everything is deductible. All right, so number 3 is what I'm going to be spending most of my time on, is the amount paid pursuant to a written binding contract under the terms as of November 2nd, 2017, and not pursuant to amounts paid attributable to services after the date of any renewal or termination of that contract, effective date, automatic or otherwise, other than attributable solely to the decision of the employee. And if it is, then you keep going. Is the amount, if it is paid pursuant to such a written binding contract, you're feeling pretty good, but there's a couple other hurdles to get through. Number 4 was the amount paid pursuant to a written binding contract as above, and not after the date of a material modification. Horrors. One thing you need to walk away with here is, whatever you do, if you're with a company, we need to back up, thanks. You do not amend any of these contracts that were in place November 2nd, 2017 without really studying what you're doing and whether it's going to affect an individual who's covered by this new law. So then you add the post-tax ongoing exclusion of the qualified plan contributions and tax-free benefits. Unfortunately, taxable benefits such as the company use of the corporate jet by executives doesn't come into that category. That would have to be under a written binding contract to be thrown back in. Add all of those together, all the written binding contract amounts, all the amounts not covered by public company covered employee remuneration, and that is your total amount deductible. Now that was pretty easy, wasn't it? What kind of guidance do we have? Well, we don't have final guidance yet. I don't think there's going to be much change in final guidance. Any kind of new interpretations by IRS has to be out in the form of proposed regs. We had a notice 2018-68 and proposed regulations that were a little rough. The notice followed by the proposed regs provide guidance on the circumstances under which certain compensation amounts and payments promised or awarded by a company on or before November 2nd, but paid in 2018 and thereafter could be grandfathered. And so again, what you want to do is identify those written binding contracts and don't do anything that would de-grandfather it, if that is a word. That's a word I like to use. But you want to preserve those contracts so as to get the maximum amount deductible that you can. Covered employees include a company's principal executive officer. After 2017 includes the CFO or any individual acting in that capacity at any time during the year. Covered employees also include the company's next 3 highest compensated officers, whose total comp for the taxable year is required to be reported in the proxy statement under the Securities Act of 1934. Let me elaborate on that point. Even if the company doesn't need to file a report, if it would have to be reported, if there was a report filed, then that compensation is included. For example, where there is a short taxable year of a public company when there's a transaction, there may be no report filed. And finally, there's no end of year employment requirement. Now, think about that. That is going to get you a lot of deductions for employees who sever. As Mike was mentioning, the Disney guy got $100 million at death. Well, if that promise had been in place November 2nd, 2017, then you apply old law. And since there was an end of year requirement that the individual be covered employee at the end of the year, that amount would be deductible. It's like playing a little game to determine if there is a written binding contract. You take your Internal Revenue Code from 2017 and apply the rules there, and you can find yourself some deductions. Most public companies have entered into employment agreements with their senior executives. Some companies have entered into change in control agreements or severance in addition to employment agreements. It doesn't have to be an out-and-out employment agreement. It could be an omnibus plans, it could be an equity plans, employment agreements. You can find a contract in many different places. The IRS's interpretation is very harsh. The grandfather rule allows deductibility for employee remuneration paid to a covered employee under written binding contract, which is not materially modified, and the proposed rates provide helpful advice. The proposed regulations also give an example that a contractual promise of future participation in an employment contract or in deferred compensation can also be grandfathered. So while the legally binding written contract must have been in effect as of November 2nd, the employee did not have to already be eligible to participate. He just had to have a legally binding contract that he could participate. And the proposed regs give you a good example of that. Many November 2nd, 2017 arrangements provide significant discretion for companies to adjust executive comp in light of changing circumstance or include unlimited negative discretion, which taken to the extreme would allow the company to reduce the payment amount to zero, even when performance and service requirements were met. To the extent that an executive's comp is legally binding and enforceable, the grandfather rule may apply to protect the company's deduction. However, to the extent the compensation is subject to employer discretion, the grandfather rule is far less likely to apply unless such amounts are, wait for it, legally enforceable under state or other applicable law, good faith and fair dealing. This can happen. In other words, although the proposed regs say we're very suspect, if a contract said, executive, you can get $20 million as an incentive bonus should certain performance goals be met. But we can ratchet it down to less than that. The IRS says it's very suspect that that's legally binding, especially if there's no floor on how far down that discretion can be exercised. Now, this is the example given in the proposed regs. In February 2017, a company established a bonus plan under which a CEO will receive a cash bonus of $1,500,000 if specified goal is met. The comp committee retains the right, even if the goal is met, to reduce the payment to not less than $400,000 if in its judgment other subjective factors warrant a reduction. In 2018, the comp committee reduces the award to $500,000. In this example, only $400,000 of the $500,000 payment is deductible, but the failure of the comp committee to exercise negative discretion to reduce the award to $400,000 instead of $500,000 does not result in a material modification of the contract. There's a lot going on in that example, but when that was put into the proposed regs, all of us out there had a collective sigh of disappointment because we were hoping that the definition of written binding contract wouldn't just be the absolute minimum dollar amount that was legally enforceable. What we wanted to see is language that if the CEO, CFO, or one of the three highest paid had a contract which was legally binding, that anything done under that contract would be good. But the IRS decided to be a little harsher, and they said, no, when we look at contracts, we're actually, it's almost like a 49A concept to me, that the definition of deferred comp, you look at every single dollar. And when you're looking at deferring, making subsequent deferrals or initial deferral elections, you do it dollar by dollar and not plan by plan or year by year. And it's kind of the same thing with a legally binding contract. You're looking at, is that dollar legally binding to be paid by the employer company? A legally binding written contract that's considered renewed after November 2nd is outside the grandfather rule. The notice makes clear that a renewal can occur actively or passively and cover a range of fact patterns. I mean, you normally think of a written binding contract as having a 10-year period or a 1-year period, but there's a lot of contracts out there that are what you call evergreen, and they just keep renewing under the circumstances specified in the contract. So an example is a CFO is a party to a 3-year employment agreement providing an annual salary of $2 million beginning January 1, 2018. And the terms of the agreement provide for automatic extensions after the 3-year term for additional 1-year periods. And this contract was in play on November 2nd, 2017. This is the typical evergreen where it's locked in place for the initial 3 years unless 30 days before the end of the 3 years, it's terminated. Termination of the employment agreement does not require the termination of the CFO's employment relationship with the company. That's an important feature because, as we'll see later on, if it did, it's okay to honor even the renewal periods. Next slide. So the CFO's annual salary of $2 million for 2018, 19, and 20, before the end of the 3-year renewal term, would not be subject to the 162M deduction limit. However, the employment agreement would be treated as renewed as of January 1, 2021, and 162M would apply to any payments made under it or after that date. So sad. Note that the $2 million only needs to be promised. It did not have to be performance-based, because in this situation, the CFO was not a covered employee under prior law. So I'm going to emphasize what I just said there. Once you find a written binding contract, you say, how much is binding and for how long? And in this instance, you say $2 million a year for the 3 years. But then you look and you say, oh my goodness, he's a CFO, and he's a covered employee, and this isn't performance-based comp. So we don't care if it's written binding. As I had described, the way to think about this is once you have a written binding, then you go in your time machine, go back in time, pull out the 2017 code, and you would say, what happens to a CFO who received $2 million back in 2017? You'd say, everything's deductible. That's great. So again, you're going to have to put your thinking cap on. The same would have applied if this is a CEO and there was severance paid under a written binding contract after he left. And so one thing to watch out for is all these severance agreements or deferred comp that get paid that were under legally binding agreements. If it gets paid when the person left under old law, that would have been deductible. There's a lot of concern with these renewal rules, but there are 3 exceptions where the renewal is kind of no harm, no foul. If the company is legally obligated by the contract at the sole discretion of the employee, that means that if the company has to have the employee buy-in to terminate the contract, then it's not just, it's legally binding because the employee has control. The employee can say, heck, I want that $2 million to continue. You can't take it away from me. So it's legally binding at the discretion of the employee. If the contract may only be terminated by the employee no longer being employed, and then the last one is that if the relationship continues but is no longer covered by the contract, then compensation after the date is no longer deductible. But jumping up to that second bullet point, it doesn't happen a lot, but it happens sometimes that you think you're out of luck. You looked at the evergreen contract and it said after so many years, maybe after 2, maybe 3, maybe 5, maybe 10, that it's evergreen, that you'd say, I'm out of luck, because that is a renewal. And renewals are bad. It's no longer written binding. But if it is contingent on the employee no longer being employed, in other words, you have this contract, and once it's over, if it doesn't continue, you are out of here, then that can be evergreened and continue on and be grandfathered. That's what these rules say. And there's not a lot of contracts like that, but we at Winston and Strawn have, by careful analyzing the totality of the contract, discovered that some of our clients do have that kind of contract. And then you'd say, fantastic, that means more deductible compensation in the future. And that makes me remember one point I wanted to make during the presentation. 162M is all about denial of deduction. When the changes to 162M were enacted back in 2017, there was a lot of crying and wailing and gnashing of teeth that performance-based pay was no longer there and companies were going to lose these massive deductions, and it was all very tragic. But we consoled our clients by saying, there. Corporate rates are so much lower. As Mike had said, oh, it dropped all the way to 21%. That's great. 21% is not too bad. You're not missing out on that much. However, let us look at the future. What do we think is going to happen? It may very well be that corporate rates are going up again. So that just alerts us that you might want to dust off the contracts and do a little exploring what was in place November 2nd and make sure you keep track of it. So that brings us to material modifications. The grandfather rule permits a deduction for compensation paid to covered employees under written binding contract in effect as November 2nd, 2017, unless materially modified. A legally binding contract that's materially modified is treated as new. And so be very careful. Compensation actually paid pursuant to the contract's terms prior to the modification is still good, but compensation paid after you messed around with your contract would not be grandfathered and subject to the deduction disallowance as under the new law. The notice defines a material modification as one that increases the amount of compensation payable to the employee. If the contract is modified to accelerate the payment of comp, a material modification will not have occurred where the payment amount is reasonably discounted for the time value of money. If the contract's modified to defer payment of the compensation, an increase in the payment amount would not be a material modification if it is based on either a reasonable rate of interest or the performance of predetermined investments. So this is kind of echoing the 162M rules talking about payment of performance-based pay. They're saying we at IRS are very sophisticated on finances. So material modification of the contract is getting at, basically, you're not going to pay that executive more than what was locked in 2017 in a written contract. But they're saying, well, what the heck, if you want to defer it out, assuming you can do that under 49A, which there's a special rule for that under 49A, or you wish to accelerate, if that's possible, also under 49A. We're saying as long as you keep it kosher and you do it taking into account time value of money, which is a reasonable discount rate if provided early. In other words, if it was supposed to be $5 million paid 5 years from now, you can't pay $5 million today and say that's the same thing. You'd have to discount it. And if you took the $5 million and deferred it out, you'd have to do it with a reasonable investment rate of return. So in January, here's an example. The CFO pays, signs a 5-year employment contract, providing for a salary of $1.8 million. In 2018, the CFO becomes a covered employee as a result of the Tax Cuts and Jobs Act. And, that CFO was thinking, darn, I thought I had a free ride on this and they could pay me anything, but the law changed. In 2019, the company increases the CFO's compensation with a supplemental payment of $40,000. And then in January 2020, the company increases the CFO's salary to $2,400,000. It's like, well, Mike would not like this question because there's a lot of math. And the proposed regulations say you can do cost of living increases on these contracts. And in addition to the time value of money, you could do the cost of living increases, whatever that proper amount is. So here there was a payment of 40 and then jumped all the way up to $2,400,000. The next slide will tell us what happens. The $1.8 million salary is paid under a written binding contract signed when the CFO was not subject to 162M, and therefore is grandfathered unless the change in compensation in either 2019 or 20 is a material modification. The 40, that first sentence isn't quite right because it really depends on whether he was ever, whether today he's a CFO. And if today he's a CFO, then you apply old law and you would say CFOs are good under the written binding contract. So you'd say, what is he now? What would happen back in 2017? And you'd say CFO does not have the limit. And so therefore that amount under the original contract is grandfathered unless a change in her compensation in either 2019 or 20 is material modification. The $40,000 supplemental payment in 2019 does not constitute material modification to the binding contract because $40,000 is less than or equal to a reasonable cost of living. Yay. So good, that is the supplemental payment, however, the 40 is subject to the limit, but not that original base $1.8 million. However, when the salary increase incurred, the $5,600, so that now he's getting $2,400,000, that's a material modification. And the additional compensation is paid on the basis of substantially the same elements or conditions as the compensation that was otherwise paid pursuant to the written binding contract and is therefore greater than a reasonable annual cost of living increase. What did that do? That's a material modification. So the binding contract was modified in 2020. Darn, all the compensation down to the bottom and thereafter is subject to the $1 million limit under that contract, not just the amount over $1.8 million. And that's why there's got to be some really hard thinking about paying more under a written binding contract, more than the cost of living amount. If the CFO had instead, and this was like a little gift in the proposed regs, proposed regs said, well, if you really get something else and you're not really affecting that contract that had the base salary, that's okay. And so they give an example of giving restricted stock instead of a salary increase. And they said that's not a material modification. And therefore that $1.8 million is preserved, even if you have the cost of living, and that additional compensation under the stock plan is completely non-deductible. So that's a little way around giving your executive more without de-grandfathering your written binding contract for some base pay. Now, non-qualified deferred comp, I really like non-qualified deferred comp, but it does have its pros and cons. Well, one of the things It's treated, there's a lot of discussion of the non-qualified deferred comp in the proposed regs. And because non-qualified deferred comp might be payable under written binding contract in 2017, you really have to keep your eyes open for it and say, when it's paid, would this have been deductible on the status of the employee under 2017 rules? And non-qualified deferred comp is usually paid when someone's gone. And under the old rules, if you make a payment when someone's gone, beautiful. So really, I hope a takeaway from this discussion is that you'll look for any written binding contracts for executives or non-executives that gets paid out to someone who becomes a covered employee, and the compensation's paid out after they leave. Because that will be fully deductible. Yay. Under a non-qualified deferred comp plan or SERP, can we back up just a bit? Distribution of the account balance or accrued benefit usually does not incur until they leave. Therefore, the distributions could be fully deductible. Yeah. Okay. Next slide. So under the new law, any new non-qualified deferred comp is going to be subject to the $1 million cap. Now, just a little planning idea here. Let's say, oh, we just hired an executive this year, and we're going to give him some nice deferred compensation plan. And we know from what we listen to, darn, this person's always going to be a covered employee, and therefore anything paid to him is going to be subject to the $1 million cap. Well, if you have deferred comp and it's payable at a mere $999,099 a year until he dies, he's going to be under the $1 million. So it's fully deductible. So even if you have new non-qualified deferred comp, it's a good way to go to get more deductions. If you had non-qualified deferred comp promised back in 2017, you're good to go anyway. But even with new ones, you'd say, geez, as long as you pay out at a rate of less than $1 million a year, you're good to go. I think we're ready for the next slide. Under a deferred comp plan, here's an example: an employee who is not a covered employee in 2015 elected to defer the entire amount, $200,000 of a 2016 bonus. The bonus plus earnings based on a predetermined actual investment will be paid on lump sum or separation in 2018. She's promoted to CEO. She separates and receives $225,000, the $200,000 bonus plus the $25,000 in earnings, assuming the earnings were part of the legally binding contract in place. The full $225,000 is grandfathered and not subject to 162M. Next slide. If the deferred comp could be amended or terminated, sadly, most plans can be. So you're rolling along with a deferred comp plan, but virtually all of them say in there, we can terminate. It's our employer discretion. So normally it's only the account balances as of November 2nd, 2017 that are grandfathered. If it was an unusual deferred comp plan, but I actually had a client with this that they said, CEO, if you come, we're going to put away X amount of dollars of deferred comp every year you're working here, and we can't change that. And it was like part of his employment contract, you're good to go. But most non-qualified deferred comp plans say the employer can terminate the plan at any time. Next slide. You need to take actions to preserve the grandfathering treatment, inventory all your comp plans, list the employees covered by the plans as of November 2nd, get legal advice. This is where you need to call in the lawyers. I've had some accounting firm friends refer us business at Winston because really it's a legal analysis to look under state law to see if a contract is a legally binding contract. Next slide. Look at how long the grandfather protection will last. Don't make any changes. If some of it is performance-based, don't go to sleep and think, oh, I don't need to do anything. To keep it, if it's a legally binding contract, and has performance-based comp, you've got to go through the actions of it being performance-based comp if it's an individual who is a CEO or one of the 3 highest paid currently, because under old law, they were covered employees. So you need to meet all those 162M old performance-based goal requirements, which is shareholder approval, the outside directors, et cetera. And continue to have the comp committee certified. Look at how long the grandfathering treatment will last, et cetera. So that slide's kind of redundant. I think we're on to, I think you can advance the slide. Another one, I think we are ready to pass the wand to the other dismaying change by the Tax Cuts and Jobs Act that kind of was cruel to all those tax exempt organizations and said, we don't want them paying too much money either. There's not a lot that do. Most tax exempts are kind of hand to mouth, but there's some big ones and they're paying out some big money to their executives. So to mirror the 162M, there's an excise tax on these companies, 21%, and we'll let Ariane walk us through that.
Sounds good. Thanks, Steve. So now we'll move on to Code Section 4960, which, as Ruth just mentioned, is very similar to 162M. It just applies to tax-exempt organizations instead. So obviously, kind of makes sense to present both of these code sections at the same time. So like the 162 amendments, this section was added to the code pursuant to the Tax Cuts and Jobs Act and was generally effective starting in 2018. And it kind of puts tax exempt organizations in a similar position as for-profit organizations that are subject to Section 162M, as well as code sections 280G and 4999, which the latter of which impose adverse tax consequences with respect to the payment of excess compensation in connection with a change in control. There's similar kind of underlying policy goals on both of these fronts. And accordingly, Section 4960 imposes an excise tax upon applicable tax exempt organizations. So the two relevant pieces of guidance that we have with respect to Code Section 4960 are Notice 2019-09 and the proposed regulations, which came out in June of this year. And the guidance was, the intent behind the guidance is to answer, all these questions to help determine who is covered by these rules and what excise taxes ultimately do. So it's, what entities are covered, who are considered covered employees, which taxable year applies for excise tax purposes, who's liable for any tax that's due and how is it reported and paid, what is considered remuneration for purposes of the excise tax determination, and then what is an excise tax or an excess parachute payment under Code Section 4960. So our first point here is determining who these rules even apply to. So an applicable tax exempt organization is an entity that fits into one of the four categories that are listed on the slide. So a tax exempt organization for purposes of Code Section 501A, a farmers cooperative organization, an entity whose income is excluded from taxation under Code Section 115.1, or a political organization. And for purposes of 4960, we're also concerned with related organizations, which are generally affiliates of the ATEO or controlled by the ATEO, or entities that are considered supported or supporting organizations. For an ATEO that's a VEBA, it's a related organization is also a person who establishes, maintains, or makes contributions to the VEBA. Under the proposed regulations, governmental entities such as colleges and universities that don't have determination letters that recognize their tax exempt status under 501A and that don't exclude income from their gross income under 115.1 are not ATEOs, but they could still be liable for the excise tax if they qualify as related organizations to an ATEO. And a governmental entity that has this kind of determination letter can relinquish that status and then avoid becoming an ATEO. The proposed regs also clarify that foreign organizations that would otherwise qualify as ATEOs are ATEOs unless they're subject to certain provisions under the code that exclude foreign organizations from the application of certain excise taxes, which is generally if they receive substantially all of their support from services or from sources outside of the US. So similar to Section 162M, the requirements of Section 4960 apply to an ATEO's covered employees for a given year. So this would include any employee, either current employee or former employee, who is either one of the 5 most highly compensated employees of the organization for the taxable year, and notably there's no dollar threshold for this, or who was a covered employee of the organization for any taxable year beginning after December 31st, 2016. And just as with 162M, the refrain, once a covered employee, always a covered employee, comes into play. So, you know, once somebody falls into this category, they will continue to be a covered employee basically until their death. It doesn't matter if it's a former or current employee. There are some exceptions to the covered employee designation. The proposed regulations include limited exceptions that would allow employees to be disregarded when they're determining an ATEO's 5 highest compensated employees. Can you go to the next slide, Steve? Thank you. So 2 of the examples from the regulations are the limited hours exception and the employee of taxable organization exception. So the first one, an employee is disregarded if neither the ATEO nor any related organization pays remuneration to that employee for services that are performed, and if the employee performs only limited services, which in this case means that they devote no more than 10% of their total hours to services provided as an employee of the ATEO. And then the second exception comes into play where an employee of a taxable organization that is who is not paid by the ATEO itself and who primarily provides services to the taxable organization is providing some services to the ATEO. So for example, an employee of a company who's providing services to a related foundation would not be considered a top 5 employee of the foundation as long as the taxable organization is the sole source of remuneration. So when this code section came out, there were a lot of questions as to which was the applicable year used for calculating the excise tax. The code section refers to remuneration paid for the taxable year, but doesn't specify which taxpayer's year applies. So the question was, is it the ATEO, is it the related organization, or is it the employee? And then it was also unclear how remuneration would be measured if the ATEO and the related organizations have different taxable years. So the proposed regulations note that remuneration is considered paid for a taxable year if it's paid during the applicable year, which is the calendar year that ends commensurate with or within the ATEO's taxable year. And this remuneration is the same as the remuneration that's used to identify the covered employees for that year. The regs also address the issue of a short year, which would happen either when an organization first becomes an ATEO or at the end of the life cycle when it ceases to be an ATEO. And so basically in the first instance, the applicable year would begin on the date that the entity became an ATEO and end on the last day of that calendar year. And then in the second case, it would begin on January 1st and end on the date that the ATEO status terminated. So now, the big question is, who is ultimately liable for payment of any excise tax that becomes due under this code section. So ultimately, it's the common law employer of the covered employee for federal tax purposes who will be liable for any excise tax that is owed under 4960. Any amount that's paid to a covered employee by a related entity for services that are rendered to the common law employer would be considered paid to the employee directly by the employer. And if the covered employee is employed by both an ATEO and a related organization, then each employer becomes liable for any excise tax. The notice includes a method for allocation of liability among the ATEO and related organization who are joint employers. The excise tax is reported on Form 4720, and each ATEO and related organization who has liability for the excise tax would have to file a separate form. So obviously central to this determination as well is, what are we talking about when we say remuneration? So remuneration is any, effectively any wages that are paid during the calendar year that ends with or within the ATEO's taxable year. So this would include, wages other than contributions under a qualified retirement plan. It would also include any amounts that are no longer subject to a substantial risk of forfeiture during that year, even if they're not paid until later on. But parachute payments are also included. However, they will not be subject to tax as excess remuneration if they're also subject to tax as an excess parachute payment, which we'll talk about in a couple of minutes. So these amounts are not doubly subject to an excise tax. The Code Section 4960 doesn't have the exact same concept of grandfathering that 162M does, but there are a couple of provisions that have kind of the effect of grandfathering. So certain vested, non-qualified deferred compensation is excluded as remuneration. So it's just not considered when you're, figuring out if $1 million of compensation has been paid in the applicable year, including any vested but unpaid earnings. But if there are any earnings that subsequently accrue or that vest separately, that vest later on vested amounts, they will be treated as remuneration and could be subject to excise tax for the year in which those amounts are paid. So the other piece of Code Section 4960, other than the excise tax and excess remuneration, is the excess parachute payments concept, which is kind of the language that's borrowed from Code Section 280G. So this is a separate excise tax that's imposed on compensatory payments that are contingent on a covered employee's separation from employment that exceed 3 times the covered employee's base amount. So, much like the 280G determination, the base amount is the average of the covered employee's 5-year W-2 compensation. And if the payments are greater than 3 times that base amount, the excess parachute payments equal anything that's over 1 times the base amount. And the excess payments are subject to the 21% excise tax. The concept of separation from employment under 4960 for purposes of excess parachute payments, it's generally the same as a separation from service under Code Section 409A, but this also includes a change in status from employee to independent contractor. As with so many things in this realm, it's a facts and circumstances determination. A payment is treated as contingent on a separation from employment if the facts and circumstances indicate that the employer wouldn't have made the payment in the absence of an involuntary separation from employment. The relevant payments here are those that are in the nature of compensation, and there's some examples on the slide, including wages, bonuses, severance pay, payment of deferred compensation. And we'll wrap up here with just a very quick comparison of 4960 to 280G. The rules are generally very similar, other than when the excise tax applies and who is responsible for payment of it. 280G and 4999 work together to apply to compensatory payments that are made in connection with a change in control. And if there is an excess parachute payment, the company would lose the deduction for that compensation, and the employee is responsible for payment of an excise tax, in addition to regular income tax. Whereas 4960 applies to separation payments, regardless of whether there's a change in control. It's not relevant to this analysis. And only the company is liable for the excise tax. So it's effectively the equivalent to a loss deduction for the company. That's all we've got for this portion.
Great. Thank you very much, Ruth and Ariane, for the excellent presentation. We did get a few questions. We're running short on time, so we will follow up with you on those questions. One of the easy ones is, will a copy of this presentation be made? Yes, it will be made. You'll get an email about that following the conclusion of today's symposium. If you're attending via phone, please take note of the CLE code, which is 082520. So if you didn't receive, you should receive a reminder email that includes a link to the CLE evaluation form, as Joe mentioned earlier. It's going to be circulated again. So we're going to take a 15-minute break. Starting at 4:30, you will want to come back and listen to the excellent presentation that is lined up, which will focus on the legal and practical challenges inherent in offering executive compensation plans by privately held employers. So that's a great presentation. Please come back within 15 minutes to hear that one.
Welcome back, everyone. I'm moderating the third panel. It's my pleasure to introduce my two colleagues. Joe Adams is a partner at the law firm of Winston and Strawn. He focuses his practice exclusively on employee benefits and executive comp, and he has represented some of the largest companies in the world and many prominent C-suite executives with respect to such matters. Joe is a fellow of the American College of Employee Benefit Counsel and was recognized as the best lawyer in America, Lawyer of the Year for Employee Benefits in 2013, 2018, and received his undergraduate degree with honors from the University of Chicago and his JD degree cum laude from Cornell. Joe also served as editor of the Cornell Law Review. Don is the managing editor or managing director and practice leader of the Executive Compensation North America division for Willis Towers Watson's Reward line of business. He's based in their Chicago office. He's a leading expert and sought-after consultant and speaker on corporate governance and executive pay and performance, with over 40 years of experience consulting with major corporate boards and executive teams across the country. Don holds a doctorate in education in principle-based corporate governance from Fielding Graduate University, an MBA degree in finance from the University of Chicago, and a BA in economics from DePaul University. Joe and Don, the floor is yours.
Very good. Thank you so much, Catherine. Why don't we move on to the first slide here? So as Catherine mentioned, I advise boards of directors and management teams on executive compensation, which I've been doing for almost 40 years. I lead the compensation practice across North America for Willis Towers Watson. And while I have advised many publicly traded companies over the years, I've always advised a significant number of private companies of sort of all shapes and sizes. And when we're talking about private companies, I think it helps us to start with, well, what do we mean by a private company? And what are we going to focus our conversation on here mostly this afternoon? So this chart shows that there's really a whole range of private companies, starting on the left-hand side of the spectrum with employee-owned companies, which includes ESOPs, moving over to co-ops, family-owned businesses, family and founder-owned businesses, where we're going to spend most of the time today, investor-owned businesses, private equity, and venture capital. And each one has its, its own, its type of ownership structure, its own sort of, time horizon, decision-making process, level of employee participation in management and governance and compensation, and degree of risk and financial leverage. And you sort of have to know who you're dealing with before you go in. You certainly can't assume they're all the same, and you definitely cannot, as an advisor to a company on executive compensation, you cannot go in assuming that everything that applies to a public company applies to a private company. That's a sure way to get in a lot of trouble pretty quickly. So why don't we move on to the next slide, and we can talk about why, private companies, in understanding private companies is so important. Certainly our practice is, we're doing more and more and more work every year with privately owned companies. The market is really dominated more and more by private companies. There's only, this slide says 4,300 publicly traded companies. I think it's actually under 4,000 now. And it's been, roughly the same for since the very early 2000s. There used to be, 7,000 or more, and it's now, virtually half of that. And it doesn't change. I mean, there's new IPOs and there's companies that go private and merge, and it stays about the same. And of course, those are, some of the very, very largest companies. But, the vast majority of companies are privately owned. And there's a huge amount of money out in private equity and venture capital hands that is making the private company market very, very, very robust. And we've seen an awful lot of private companies that, are staying private, where in the past they were planning for an IPO, and today it's quite common for a company to be private and intend to stay private. Next slide, please. So, 80% of companies worldwide are private. 60% of workers in the U.S. are working for private companies. Significant majority of new jobs are created by private companies. So anyway, it's a big part of the economy. It's very important. Another thing that's really interesting is that private companies, usually start out with some founder or family that starts them up. But only 30% of those companies survive to the second generation. It's very, very difficult for a founder to be able to transfer the leadership and ownership of the company to a second generation of the family, or to what we call professional, non-family management. It's a very challenging thing to do. And an even smaller percentage of companies make it to the third generation or fourth generation of family management and ownership. Another interesting fact is, relatively small percentage of family-owned businesses really feel like they do a very good job of corporate governance and have, an effective board. Now that's changing. There's a lot more attention these days by private companies and by all manner of corporate governance groups to governance of private companies. It's a very popular, important area right now, but it's still a small minority companies that do a great job of governance and hence do a great job of designing and monitoring and managing executive pay. Next slide, please. So this is based on a study that was done by McKinsey about what makes for a successful private family-owned business, and particularly one that's going to survive successfully multiple generations. It's almost imperative that they have good governance processes and a board of directors. They tend to have what this study called family gravity. And I'm putting this up here because this reflects my experience working with, many larger, successful family-owned businesses over the years. They tend to have a set of values, very common for them to have. Sometimes they're emblazoned on the wall or on the website or in their brochures. Sometimes you ask them about it and they rummage around in their drawer and they find some document that they refer to every once in a while that has the values written down. But there's something, and there's something they rely on. They tend to have a vision for the future in terms of where they're going. They tend to have a longer term focus. They tend to put their customers and employees first. And they do tend to have a sense of social responsibility. And by that, I mean that they understand where they fit in the business community and in the communities they operate in, and they understand their role as a member of that community, as an employer, as a vendor, as a supplier, and how they fit into the ecosystem of that community, and how important they are to that. They also, the ones who survive tend to do a good job of developing future leaders, whether that is the next generation of family members or people that they hire from the outside, and they tend to make sure those people fit the culture of the business, and then they along with that also have good CEO succession planning, because I would say probably that's in the area where most private businesses fail to move forward, is being able to transition from that founder or family, scion, who started the business, to the next generation. Next slide, please. So, next slide. Okay, thanks. So when it comes to compensation, so that's sort of the bigger picture around private companies. When it comes to compensation, we see wide differences between private companies. So public companies, well, there's certainly significant variations between one public company and the next. There's a lot less variation in public companies. Public companies, tend to follow each other. They publicly disclose their pay practices, so they copy each other, and they are constantly competing with each other, to have the best pay programs. And they're also under incredible public scrutiny, so they tend to not deviate too much from a sort of normal set of practices. Private companies have a much wider range of compensation practices. And part of that is because they've sort of grown up, on their own and figured out what worked for them as they went. They're not under public scrutiny, and they tend to sort of figure out what works best for them. That said, private companies do, especially as they get larger, they have to compete in the public market. So they have to have pay programs that either they can explain really well, or they have to look and feel somewhat like the public company programs. Because public company executives are going to expect to see things that they recognize, that they understand when they come into the private companies, if they're going to be recruited. Private companies, and now we're going to get into some of the more detail here. Private companies, and we study this. We have a database of over 1,000 companies, but about a quarter of which are private, the rest are public. And so we can make comparisons between public and private. And private companies tend to pay about the same salary, about the same annual incentive, but tend to pay either they don't have a long-term incentive, or the long-term incentives tend to be less valuable. That shows up in the data. What we know, not from the data, but from practice, is that the long-term incentives will tend to be will tend to be less variable. Yeah, go ahead, Joe. Next slide. Another factor that affects this wide variation is, does the company intend to stay private forever? Some companies do or say they do, or are they planning on some kind of transaction? We always ask them, what's your end game? Are you planning on selling the company or going public? If they plan to stay private, it's one whole set of pay plans that are going to work for them. If they're planning on selling at some point or going public, then it's a different set of plans that we'll develop for them. Next slide, please. Some of the emerging best practices in private companies that we're seeing that have a significant effect on executive compensation is more and more private companies are choosing to adopt public company governance practices. And that means that they'll tend to start with a sort of formal advisory board, bringing in outside board members, non-family board members. And then they'll, the next step beyond that is they'll move to a fiduciary board that actually has decision-making authority and has an independent board members. A lot of times they will then, separate out all the family business from the business and set up a family council that deals with all the family stuff. That's the subject of another seminar. We can do it another time. There's a lot to that. They set up independent compensation committees. They develop compensation philosophies and guidelines to guide the directors in making decisions about executive pay. They use, benchmarking and annual pay reviews data that companies like mine provide to help them make those pay decisions. And then they get into very, tailored long-term incentive plans. Those are all the ways that and part of what they're doing with that is, let's say that, grandpa started the company or grandma started the company, and grandpa always made all the decisions, especially about compensation and sensitive things. Everybody kind of trusted grandpa or grandma to make those decisions. Well, then grandpa or grandma gets older, wants to move away from the business, or maybe dies. And now you've got to figure out, how do you make those decisions in a way that people trust? And that's really the point of setting up the governance structures, the comp committee, the pay philosophy, the benchmarking, and the actual design of the incentives themselves, is to take what grandpa did, by the seat of his pants, and then, make it formal and make it reliable and make it consistent and make it something that people can trust and rely on, that then allows the business to, to progress and survive. Next slide, Joe. When you're working with a private company, the shareholders are real people. I mean, they're real people in a public company too, but they're, hundreds of thousands or millions of investors. Here, they're actual individuals that you can and really need to talk to. And they will have some very specific views and perspectives that you've got to understand, including, what their end game is. Do they intend to stay private or sell at some point? What's the importance of the value of the stock and the business? In a public company, it's a given that they care about value. Private company, not necessarily so. They, may not be all that concerned about the value unless they really are planning on selling it. It's an idea that's interesting to them, but and hence you don't, if they're not that concerned about value, you're not going to drive it hard in the design of the incentive plan, or vice versa. What are their cash flow needs as a family and as individuals? And what's their risk tolerance? The incentive plans, are put in place to help create incentives to get people to take more risk than they otherwise would, typically. You want to put an incentive plan in place that causes them to take more risk than the owners want them to. So that's something to make sure you're aware of. And then what's their appetite for growth and reinvestment? would they rather receive dividends and not grow so fast? Or would they rather reinvest that in the business and grow faster? And that can be, you can get very, very different answers depending on who you ask, especially when you get into multi-generations in a business. Some really would much rather have the dividends than the growth, for example. And then lastly, which is really firstly, if that's a word, is to, help them get clear, make sure you're clear. What's their purpose? Why does this business exist? What's its mission? What's its values? Who does it serve? Private companies, I have found, tend to be better able to articulate those things than public companies. Not all of them, but far and away more. Because it's just something they've thought of. And it's particularly something they've thought of as they've answered questions about, gee, do we sell this or do we keep it? And if we keep it, why are we keeping it? So things like that. And that question may come up if they've got a big philanthropic objective. Philanthropic objective may be better met by selling than by keeping the business, or vice versa. But it's something you have to know. Next slide, Joe. So we're going to go through a little bit of data here fairly quickly. I've referenced some of this already. Again, we compare private company practices to public company practices, statistically. And I'm just going to point out a few, fairly, marked differences in some other places where it's the same. The pay mix, by that I mean the mix of salary, bonus, and long-term incentives is markedly different. Private companies tend to pay a lot more cash, salary, bonus, and even the long-term incentives tend to be based in cash rather than stock. Public companies, you see a much higher percentage of the pay in stock or stock vehicles. Next slide, please. I mentioned that pay levels are also different. When it comes to salary and bonus, private companies, especially as they start to get larger, pay pretty similar levels of salary and annual incentive. In some cases, the annual incentive is a little bit lower, but in most cases, it's about the same. Where the big difference is in the long-term incentive. So, these are for companies that have a long-term incentive. So even though for those who have a long-term incentive, the value of the long-term incentive tends to be lower. And you can see here that it's actually the most lower for the CEO and for the C-suite. As you move down in the organization, the difference is less. And, that's understandable because the CEO gets the most pay in the long-term incentive. The C-suite gets the next most pay, and less and less as you go down. So now I will say this, that even though the value is lower, the payouts tend to be more consistent in private companies than public. Less public or more variable. Next slide, please. Obviously, the difference is even greater for companies that don't have long-term incentives, and there's a lot of private companies that just don't have a long-term incentive. Actually, about half of the companies in private companies in our survey don't have a long-term incentive. Next slide, please. In terms of annual incentive design, next slide, Joe. The annual incentives tend to be very similar between private and public. The only main difference is that some of the performance measures are different, but even that isn't markedly different. So you can kind of consider the annual incentives to be pretty similar. Where the big differences are is in the long-term incentives, which you'll see in the next couple of slides. Let's go to the next two slides, Joe, and we'll go through these fairly quickly. Private companies tend to only have one long-term incentive vehicle. Public companies tend to have two or three. The biggest thing is in the second chart here is that the vast majority or significant majority of long-term incentives in private companies are what we call performance plans, cash-based performance plans. They're not stock-based, not phantom stock-based, they're not value-based. They're based on they're like long-term bonus plans. They're plans that pay out over 3 years based on 3-year performance, and they pay out in cash. That is far and away the majority of what private companies do, and that's primarily because doing something that's based on stock or value, as I think Joe is going to talk about, there's a lot of hoops you have to jump through to make that work, and a lot of companies don't want to do that. Next slide, Joe. So this slide and the next slide basically show two things. One is that private companies grant long-term incentives to far fewer people and far less low in the organization. So they tend to concentrate their long-term incentives at the top of the house and don't go as far down in the organization, anywhere near as far down as public companies do. That is what this slide shows, and Joe, that's what the next slide shows for different types of vehicles, right? Again, it shows that the performance plans are much more common in private companies, as we've already covered. Next slide. This slide basically shows that other than that, other than that, it's private companies mainly use cash-based performance plans. Everything else is about the same. They tend to follow public company practices in terms of how often they make grants, the length of the performance period, which tends to be 3 years, the number of measures they use. Everything else is pretty darn similar. Next slide, which I think is my last one. Oh, the performance measures are actually very similar as well, although clearly we see much less use of stock performance as a measure in long-term incentives, more revenue and profit measures, about the same amount in terms of return and margin measures as we see in public companies. Next slide, Joe. So in summary, the approach to executive comp differs in private companies from public companies in several key ways. One is they tend to be much more likely to provide cash-based performance plans and not stock-based plans. They do use value-based plans, definitely, but a lot less frequently than public companies. The grant levels tend to be lower. And other than that, they tend to follow publicly traded company practices pretty closely. And then the last point is that the pay from long-term incentives and pay in general at private companies tends to be less variable, and sometimes significantly less variable, more predictable, more reliable in private companies than public. So with that, Joe, we can turn it over to you.
Terrific. Can you hear me okay?
Yes.
All right. And Katie, we have any questions along the way you want to? That was terrific, Don. Thank you very much. I will jump in my part, which is the legal issues. You'll note here after this slide, there's a notable degradation in the quality of the artwork in the slides going forward. So here's a summary of what I was going to hope to cover, and I was going to try and do this kind of like the life cycle of a plan, sort of, and we can maybe, in the interest of time, we can hit the first couple slides relatively quickly because I think Don did a terrific job of identifying some of the objectives and considerations you would think about. And so usually when we have these types of projects, we would sit down and walk through kind of the life cycle of a plan, like a design. Who should be in the plan? What type of awards? How do you value the awards? When should they vest in them? Is there clawbacks? Those types of things. And then there's some other, when everyone's excited about that part of the project, and then you get to the messy part about tax, securities, corporate. So we've got some of those things that we'll wrap up with. And again, we encourage your questions, but that was what I was hoping to cover today. And I think if you look at that last point too, about the other issues, that sort of echoes what Katie's point was at the beginning about how multidisciplinary this area can be with all those different fields that are at play with these sorts of benefits. And Don, I agree with you too. I think I liked your slide at the front here. Let's see if I can get back to that all the way. I think that is we see a lot of that too. We have at one end of that spectrum, we have a lot of ESOP clients, and there's some very unique ESOP issues that we have for our clients. And at the other end, we have a lot of the private equity clients where they're just, burning and churning profit units all the time, sort of. So we're sort of in this middle area for most of the discussion today, but we'll touch on a couple of those ESOP and private equity things as we go. So back to the agenda for this part of the program. Okay, objectives. Like Don said, this is pretty straightforward, right? That we want to attract, retain, motivate key employees. We want them to grow the value of the business. We want to structure a program that preserves exit strategies, whether that's transitions to other family members, if it's going to stay private, if it's a transition to an IPO, to SPAC. We're seeing a lot of SPAC transactions recently. So there's lots of ways the company might go next, or may stay private forever, like Don said. And if we are thinking about some sort of a transaction, we want to structure a program that, well, if not please, at least won't be a surprise to folks that might be potential acquirers in the future. So fairly straightforward objectives, and like everything, the devil's in the detail. So let's go to some considerations. Again, some things that Don has touched on already, but we'll delve into in more detail here. One thing that's a concern is the tax impact on the company and the controlling shareholders. Again, for private companies, that can be a very important. Tax planning is particularly if we're thinking about generational wealth, how do we transfer that in a tax efficient way? Very important. And then similarly, the tax impact on the recipients. Can be some challenging issues in privately held companies, because like Don said, with public companies, if we have stock and we're giving people stock, that's easily tradable in the market. People sell it, they're liquid, they have money in their pocket, it's great. Here we're trying to give folks the imprimatur of ownership, but they don't actually have the ownership, and you can have a bad situation if people have dry income, as they call it, sort of where you've received an award, but it's and you're taxed on it, but you can't sell it, you can't do anything with it. So are we going to try and time the income recognition event to the time when there's liquidity is the thing we need to think about. Again, shareholder dilution is a concern. How much of the company do we want to, give away is the wrong word for this, but we're trying to incent the employee management team. But sometimes owners do feel like that, they're giving away this value. They've built this business with their own blood, sweat, and tears, and taking out loans, and giving away can be an issue. Or again, with private equity, they come in with an absolute metric of how much they're willing to put behind the management team, and they're not going to budge. Another consideration is accounting impact. Mike gave us a great in the history of exec comp. Mike gave us a great history of how the accounting treatment has changed over the years, and now there's no longer the same preference for stock options that there was historically. So those are certainly things to think about, the accounting impact. And then finally, federal and state securities law. That can impact, if you want to take advantage of certain exemptions, how many people can be in this plan and what sort of disclosure needs to be made. And that can present some challenging issues in private companies where people are reticent to share some of the company's financials and some of the company's financial information. All right, so let's go back to our life cycle of the plan. So when we'd first designing a plan, we would think about, okay, who should be in this plan? Obviously, it's some cadre of employees you want to be in this plan. And I thought Don's slides were good in terms of how deep in an organization you go for a private company, not as deep as public companies. It sounds like the data suggests. Are you going to also put non-employee board members on there? You're also going to put independent contractors or advisors. And that's a place where we see that accounting treatment can have an impact on that, because you get better accounting treatment if you're issuing shares to your employees and your directors. If you're issuing shares to independent contractors or folks that work for affiliates but aren't really do consolidated financial statements, the accounting treatment can be a lot less favorable for those types of awards. So that's, step one is trying to figure out which group from that universe are people that we want to put in this plan. And then I think that also begs the question, and Don, I'm sure you have points on this, is it the case that we should always be using the same type of equity award vehicle? Assuming we are, doing an equity award vehicle, we're going to have a long-term incentive plan. Should we be using the same type for different groups of employees? I think historically there's been a thought you might give more option type things to higher paid folks on the thought that they have more of an ability to change the direction of the company, and you might give more restricted stock type awards to lower level folks because there's more of a retention aspect to that. I know you spoke about performance awards, Don, so there's a range, and you probably just want to figure out, once we figured out who's in the plan, is everyone getting the same thing, or does it make sense to distinguish? I don't know if you have thoughts on that, Don.
No, I mean, typically in the plan, it tends to be, people at the top, who've got the most influence over the results of the company. And, it depends it depends whether it's a value-based plan or performance-based plan. But, by and large, it's going to be, your top executives and the people that control the major business units or run the major business units. With some selective people, down through the company, but, probably less so than you do in a public company where you can throw some stock options or shares of stock around to a lot of people if you want to, without, it's sort of an award without worrying too much about what their influence is on the performance of the company. That helps.
Yeah, definitely. Thank you. Okay, next, as we're still trying to figure out who's in the plan and what are they getting. The next question we would ask is, is it clear, and I think Don sort of gave us the answer to this in his presentation, are we clear we want to base awards on company stock value, or do we want to use some other sort of metric? And I think we do see that in private companies. There's a lot more ability to come up with a special, this other, in a public company, the biggest marker is stock price or, relative earnings per share or things like that are, commonly available. In a private company, the company, to Don's point, may have certain thought about if we encourage this type of behavior, this type of sales, this type of development, that, inures to the company's long-term value. And so we may want to have a performance plan rather than something that's purely based on stock. And then the next question is, if we are going to offer, some type of long-term incentive plan, what should be in the plan? And on this slide here, we have arrayed all the things you would typically see in a kind of a public company omnibus equity plan. Are we going to do, stock options, whether they're incentive stock options, ISOs, or non-qualified stock options? Are we going to do full value shares, whether it's restricted stock or restricted stock units? We're going to do performance shares, like Don said, could have a performance aspect to them. If we don't want to do actual share ownership, because lots of private companies want to treat people like owners but not actually give them the shares, you might think about things like stock appreciation rights and phantom equity, or we do all of the above. And it's clear in the public company context we would do all of the above, because it's just the way the listing requirements work for publicly traded companies. If you're adding these new features, you have to go back to shareholders to do this. So there's a real incentive in the public company context to throw everything but the kitchen sink in the plan, so we don't have to go back to shareholders. We have to go back on a regular basis to ask for more shares, but we don't want to have to go back and say, oh, we last year we did this thing, we'd like to do this other thing. Put it all in an omnibus plan. In a private company, it's kind of the reverse. There's still some state law approval requirements about who needs to approve this plan, but we can be very focused and tactical about we're just doing a performance share or a phantom share plan now, and if we need to do something else later, we'll do it later. That's it. And then I alluded to at the outset, the profits interest is very specific for a lot of private equity backed companies. Very focused. We see a lot of people doing that. So I have one slide on that we'll get to in a second. The next slide is, okay, so now we've tried to figure out, again, what kind of awards. We're still trying to figure out what kind of awards to give to people. I think this is a helpful, distinction, and Don mentioned this as well. Do we really want to give people appreciation-only awards, or do we want to give them full value awards? So if you think in the chart there, when we're talking about appreciation awards, we have a stock price as of today, a value of the entity as of today, and we're going to give people the upside from there. So if the business doesn't go up, they don't get anything at all. But they don't really lose anything either. It's only if the value goes up. Or do we want to give people full value shares, where they will presumably get a significantly less number of those because they're worth more, but they're always going to get something, the value of the shares on the date of the company. So in that case, if you're doing that and you're using actual equity, you'd be issuing restricted stock units or actual restricted stock. And if you want to stay with phantom, you don't want to give people actual ownership. You want to give them phantom equity. The equivalent there would be phantom stock. So that's always seems to us to be one key design decision is are you going to do actual equity or phantom equity, and you're doing upside only or full value. Don, do you, I'll call on you for a question. When we're usually thinking about this, we would say, is it still thought to be sort of a 3-to-1 or 4-to-1 ratio in terms of, how many options you'd get versus you get 4 options for every share of restricted stock?
3 to 4.
3 to 4.
Yeah.
You'd get more. So a lot of this depends on, again, the executives might have a different point of view on the growth perspective of the company. If the company's going really well and they think it's going to grow, they want more shares. They want to take more exposure. So they'll want the appreciation only awards, figuring they'll get 3 to 4 to 1 of that. If they just get a restricted stock share, they won't get all that upside. So that's a design feature we usually talk about with clients about. And again, it begs the question of, do we want the same thing for everybody in that group? I'm going to just hit on one last design issue on the type of award before we move to the next section. And this is with profits interest. Like I mentioned, a lot of the private equity firms, this is pretty much the only thing they seem to be offering for incentive comp for private equity held companies. This is an actual interest in the partnership that someone's getting. They share in the profits. But the key is here, most often from the management team, they may buy some shares, they may buy some actual shares, units in the plan, but frequently these are profits interest, and they're granted at liquidation value, so they have no value when they're granted to the employee. And the magic here is that when the employee gets the award, there's no taxable income to the employee at the time they get the award. They're treated as a partner. They typically make an 83B election is what we recommend, and is a pretty standard playbook for how to do this. But the benefit is that any upside in those profits units are taxed at capital gains under current tax law. It's something that's sort of Katie and Mike's discussion earlier about what might be changed in the future. There's always been a thought that we should change the taxation of profits interest to make that more fair, that looks more like wages than capital gains. But it's under current law, it's treated as capital gains, subject to a minor limit that was passed a couple years ago by President Trump. The corresponding employer treatment there is that they don't get a deduction, though. So there's a trade-off there. But that's very common, and we see a lot of private equity firms, like I said, have a very standard playbook about here's how much we're putting to the employee profit interest pool, and the CEO can take this amount and allocate the rest to the rest of his or her team. Okay, the next thing in private companies we have to think about is how do you value these things, right? And unlike in a public company where the stock is traded every day and if we've got a price, we can figure out what it is without any consternation. In a private company plan, there's no formula, and lots of times companies use book formulas and such. So the plan may say that the board of directors has the discretion to determine how to value the plan. What is tricky here, particularly we mentioned 409A a couple times during the course of today's presentations, is there's a very tricky tax issue if you are granting stock options or SARs for private companies and you don't have a good valuation. That can pose a problem. The idea here is that the IRS has long been concerned that companies play games with this and they issue stock options at discounted exercise prices. And this was a technique that was used I think in the early 2000s. One of the consulting firms was selling this idea where we go out and issue, we give Don an option on $200 worth of Vanguard or Fidelity mutual funds with a $100 strike price. And he can avoid all these crazy rules because it looks like it's an option and he can exercise it whenever he wants and doesn't have to comply with deferred comp rules. And so in 409A, the IRS shut that down and said an option is only exempt from 409A if it's 3 things. It's granted on company stock, employer stock, it's granted at fair market value, and it doesn't provide any deferral opportunity other than the option itself. So you can't exercise the option at 10 years and then roll it out. So one of those key things is that the option always be granted at fair market value. So that puts a lot of pressure on making sure if you're issuing those types of awards and you want to take advantage of them being exempt from 409A, that they're granted at fair market value. And there's ways to do that. We work with companies on how to do that. Like with the ESOP companies, they will have an ESOP valuation, so sometimes you might look to the ESOP valuation. Other cases, the 409A regs have some rules, and they're, it's got a double use of the word reasonable. We have to use a reasonable use of a reasonable valuation method, so it's got to be super reasonable is the headline, and make sure that that's it. But it comes up in deals a lot about how to make sure that the options are priced fairly. Oh, I'm sorry. And then that slide too, there's also, thinking about fair market value. If you're drafting these types of plans, are we taking into account the value of these awards themselves so that things are essentially done on a fully diluted basis? Again, that seems to happen pretty well in the private equity plans where everything goes through the waterfalls, but some of these other plans, you want to make sure you take that into account. So, okay, our next design issue is we've figured out who should be in the plan. We figured out what we're going to give them. The next question is, when should awards vest? Traditionally, things are always vested on a time-based schedule. Now, I think it's more common that there would be a combination of performance-based vesting and time-based vesting. Again, that seems to be a trend in the private equity companies. I don't know. Do you see that as much, Don, in your practice for non-private equity companies, just other private companies? Are they certainly maybe are making the awards based on performance, but is vesting also a performance trigger?
It is for stock, right, but not for options.
Okay. Excellent. Excellent. Yeah, so in the private equity context, you'll see very clearly that Don's getting 100 profit units and 25 of them vest over time, a quarter each year, and the balance of them vest on once the equity owner has taken out this much profit or whatever, got double their money back type thing. So, there's a design choice there in terms of how you want to vest these awards, and then another design choice about should we accelerate the vesting of those awards on death or disability or change of control, termination without cause. And reasonable minds can differ on that in terms of death and disability and termination without cause. It'd be nice to provide some vesting there. On the other hand, some people think, well, I'm going to have to hire somebody else to take this person's spot, so I can't fully vest these awards. So that's some of the things you think about there. And change of control historically has been a full vesting trigger, but now you think about, does there need to be a double trigger? Does a certain rate of return have to have been achieved in order to get full vesting? So there's ways that has gotten more complicated in the past few years. The next thought is, so people have vested in these awards. Is there any way they can lose the awards? And so frequently we see when we're designing these types of plans, should we have a forfeiture of these awards if people violate restrictive covenants like non-competes and non-solicits? And that is a common approach because lots of times, particularly if you have employees that have worked for you for a long time, it's hard to kind of unilaterally impose a restrictive covenant like a non-compete on somebody unless you're giving them something new. So if you give them some new equity bonus, any of that, it's a place where a lot of employers like to stick a restrictive covenant and say a condition of you getting this award is you complying with this restrictive covenant. And so people could forfeit it, and then a corollary of that is if we have this, should we have a clawback in that even if people have gotten it, can we claw it back at some point if they've done something bad with respect to those restrictive covenants, or if the company has had a financial restatement. Clawbacks are more common in public companies. I don't know if you see them much in private companies, Don, but
not at all. No.
Yeah. Okay.
I mean, if the private companies, no. I mean, I think private companies, the board tends to figure they can, they can kind of do whatever they want to do, and they're not worried about, public scrutiny about it. So no, I rarely see it in private companies.
Yep. Very good. And then the last question is, okay, so people are vested in these awards. They haven't violated their, the restrictive covenants. How long can they hold these shares? Assuming they're vested, can they continue to hold them after they leave? And get to this later in the slides. A lot of private companies will say you can only hold the shares while you work here, that we have a right to call those shares back from people once they terminate employment. What can be a challenge in some of these things, depending on how it's structured, is can the company have the discretion to do that? If you sometimes don't want to create a situation where if Don leaves, he was a great guy and we want to let him keep holding his shares for a while. You know, we had to fire Joe. Joe wasn't doing that great of a job, and so we don't really want to cash out Joe right now because that makes it seem like he's getting liquidity earlier. You know, the bad guy got liquidity earlier than the good guy. So can the company have discretion when to do those things? And a lot of that comes down to whether the award is subject to 49A. If it's subject to 49A, it can be challenging to do those types of things because you can't have a payment event that's triggered on, you know, Don was a good guy, so he doesn't get paid. Joe's a bad guy. He's getting paid right now. So you have to think about that. If you want to have that sort of discretion, you might want to make sure it's exempt from 49A. All right, next. When should an employee be able to receive money with respect to these things? Is it at a specified period of years that you would vest in these awards and get paid? Is it an employment termination? And again, that could trigger a 49A concern if you're vesting in these awards at some period of time, 3 to 5 years, but you don't get paid until your termination of employment. That will mean that these plans will be subject to 49A, and you just have to think about how to comply with that or try and find a different exemption. But anytime we have a vesting in 1 year and a payment in another year, we have to get our 49A antenna up. And then we've seen other cases, and this is sort of in the startup context, where people might say, we want to, we're giving you these shares, restricted stock, let's say, and you can only really exercise it and get liquidity upon an IPO. And again, this goes to Don's point about what the exit scenario is. But under 49A, typically they would say, well, here's an RSU, it expires in 5 years if we hadn't had our liquidity event, meaning an IPO. And the idea is that there's a thought that that's a substantial risk of forfeiture. It might not happen. We might not go public in 5 years. So even though you're vested in this amount, there's this risk of forfeiture that you might not get it because we might not go public. And therefore, if we have an IPO, we can pay you right on the IPO, whereas most 49A awards can't be paid in an IPO. So it's kind of a clever way that's used in Silicon Valley approach to try and pay people on an IPO. The problem that comes up frequently is people say, oh, okay, well, you got to make the likelihood that this will be paid. There has to be a risk, a substantial risk that it won't be paid. So we'll say you have to have the IPO trigger within 5 years. And then the company is not really ready to go IPO in 5 years. So you're getting like, can we kick this out like to 7 years or 10 years? And so lots of challenging issues you have to think about there. And then I touched on this earlier. If we are using actual shares and we're delivering the shares, you know, in a private company, there's likely no liquidity. We are aware of some clients that create internal markets to sell shares. I'm aware of some consulting firms that have done this, but frequently there's no liquidity. So you have to figure out how will we do this with folks where they don't have the money to pay the tax bill, and if in the case of an option, the exercise price. So you know, frequently you might arrange a situation where the exercise price can be paid via net settlement. So if I have an option or a stock appreciation right on a certain number of shares, you just pretend that I delivered you the exercise price and you issue me the net number of shares. And so that saves me having to go out of pocket. And you can do the same thing with respect to the income tax and the employment tax. You know, just hold back some of the shares for the company to cover that liability. So if we're delivering actual shares in the private company, those are some of the techniques people do to help with that liquidity crunch. All right. Those were my design things. And now I'm going to go into the next section of, you know, we sort of figured out who we want to put in the plan, when they're going to vest, when they're going to get liquidity. These are, the next 4 slides are going to go through some other issues that you'll want to think about if you're rolling out one of these plans. The first question is, are there any existing award plans that need to be replaced, and how are we going to feather in what we have already and where we'd like to be? The next question is, do we have, what should be the effective date of the program? It seems, you know, I have a partner here that always comes in and says, hey, we put in this ESOP a year or 2 ago. We promised to give people, you know, equity. Can we still do that now? We just never got around to papering those grants. And the answer is usually we can do that, but we'd have to think about how to best do that. Mike Melbinger talked about some of the perils of backdating, so we certainly don't want to be backdating things. But lots of times, if you get to the structure of, we promised to give Don 100 shares of phantom stock 2 years ago, and it was going to have a 5-year vesting period. Then we're like, fine, we'll just start the vesting clock. He'll be 40% vested right when we grant these things to him. We can draft them that way. Or if it was supposed to be an option that was granted 2 years ago and the stock value has gone up based on a fair market valuation in the past 2 years, then we might say, great, we're going to issue you a new stock option today with the current fair market value, and we'll capture that discount that you've missed due to our delay in issuing the stock option for the last couple of years. We'll put that in a deferred comp plan, and we'll just bonus that to you now or something like that, and that way we won't run afoul of 409A. So you just need to think about doing this. It's not that you can't do it, you just have to do it in a smart way if we had a founder made a promise to folks to make some of these grants earlier. The next question, sort of in the general category, is who will administer this plan? Like Don said, I think we are seeing increasing formality with these companies. So is the board or is a compensation committee going to approve this? And under what circumstances does management have the ability to do some of these things, to grant awards or do administrative stuff without having to go back to the board every time? So that's something you usually want to put in the plan. And the last general concern we had is wanted to raise is ERISA, believe it or not. ERISA typically can be avoided with these types of plans. They are usually designed not to be subject to ERISA. The key test is whether payment under the plan is tied to termination of employment or retirement. If it has a practice of tying to termination of employment or retirement, then an incentive comp plan like this could technically be an ERISA plan. And there's rulings out there that suggest if a stock option or an SAR lasts for 20 years, that could theoretically be an ERISA plan. So there's lots of reasons you want to have shorter exercise periods, including the financial statement expensive options and SARs, but certainly that's one reason that those tend to be 10-year programs. If you do have a program that ties more towards retirement or payment, termination of employment, then there's an approach where you might limit something like that to a top hat group, which is meant to be a group of folks that are sophisticated enough that they don't need the protections of ERISA. And so we can always help you do that. But we think about that and sort of the range of 1% to 5% of the workforce is the right group for a top hat plan. If we need to have a bigger group in the plan, then it's better to make sure that it provides for an in-service payments, which a lot of these plans do. All right, let me just check time. We're right on schedule. Okay, next issue is tax. Like I said, there is a lot of tax issues involved in these types of plans, and this is just a short list. We had already some discussion about 409A and how complicated that is, and the challenge there is that generates solely negative tax effects for the participant. A lot of other tax provisions, 280G. We talked about the 162M in Ariane and Ruth's presentation. Those other provisions can have impact on the company, but 409A really only affects the participant, and it's sort of one of these challenging things that if something's done wrong, the participant doesn't know about it, doesn't really have much line of sight into the drafting or the design of these highly technical issues, but they're stuck with the tax bill. So you need to be very careful about that. And there's a way to think about, are we complying with just because something is subject to 409A doesn't necessarily mean it's a penalty. You just have to make sure you comply with 409A. So in a lot of these awards, we're trying to figure out, do we want to make this exempt from, if we're doing a stock option, then great, we got to make sure it's really subject to, we have a fair market value, right? It's the right kind of employer stock, and it doesn't provide for deferral. On the other hand, we might say, we can live with 409A because people don't really want liquidity anyway while they're working here. So why don't we make this, we don't have to worry about getting the fair market value exactly right. We'll concede that this thing is subject to 409A, this option, let's say, because we're not positive the fair market value is right. And then that means it has to comply with 409A. It can only be paid on termination of employment, change of control, death, disability. And companies might say, that's perfect. In a private company, those are the times we want liquidity anyway. So there's always a sort of trade-off between, do we want to comply with 409A or do we want to try and draft so that we're around outside of 409A? We've talked a little bit about 83B elections. At a high level, if you're getting restricted stock, and this is only done with restricted stock, not with restricted stock units. Sometimes it's done with early exercise stock options. You'll see this as well, where people will make an election at the outset to have the entire amount included in their income at grant. And the benefit of that is that the subsequent appreciation would be treated as capital gain. So you've sort of closed off the compensatory piece of an employer giving an award to an employee, and you've ideally done that at a point when the value of the equity is relatively low. And the risk of, and then everything else of that would be capital gains. So this is great for, what we call cheap stock. It's worth $1 now, and we think, if this company's going to go IPO, it'll be worth $100, and that delta between $1 and $100 will all be taxed at more favorable capital gains rate rather than ordinary income rates. So that's the benefit. The risk of doing that is that if you don't stick around long enough to vest in those shares, or if the value of those shares decline, you're stuck with a loss. That's the risk of doing it. So, and there's some other one other thing is there's a very strict timeline. People are generally pretty good about this, but there's a very strict 30-day timeline for making that 83B election, so you have to be aware of it. The good news over the last couple of years, the IRS has issued and I think revised a model form for making the 83B election. Another tax rule that comes up a lot in private companies is if we are going to use stock options, should we think about making them be incentive stock options? And there's a benefit on that that, again, public companies don't use. We see very few of our public companies use incentive stock options. A lot of private companies use incentive stock options because when an employee exercises that incentive stock option, assuming everything's set up correctly, they don't have to include in their income, at least for regular income tax purposes. It is a preference item for AMT, but they don't have to include in their regular income the spread on that option exercise. So that is a windfall for the employee as long as they hold the shares for a certain period of time, which they don't have what's called a disqualifying disposition. They basically have to hold it from 2 years from date of grant or 1 year from date of exercise, whichever is longer. So they have to do that to maintain that favorable tax stream. But if they do, that's a windfall for the employee. The trade-off is that the employer doesn't get a deduction for a regular ISO exercise, assuming it's not one of those sales too soon, a disqualifying disposition. So there's some benefits, and particularly for private companies, that can't use the deductions early on. We see some private companies, as opposed to public companies, using incentive stock options for that reason, because they feel like they're giving a benefit to the employee in terms of this favorable tax treatment, and it's not necessarily costing the company that much because they can't use the deduction in their current tax position anyway. The other thing that comes up in some of these exec comp plans for private companies is 280G. And we had some discussion on this already in Mike's presentation about why this was put in and what it was trying to stop. The good news here is that the private companies can work their way around 280G by doing a shareholder vote. So that is what a lot of private companies do. It sometimes requires it often requires some sometimes awkward disclosure to shareholders about what everyone's getting. But that can be done. And then the last thing, and I know we're getting close to our time here, is 409P. For ESOP companies, there's some specific rules if too much value is going to shareholders in an ESOP-owned company, S Corp, there's some limitations on that. Let me just try and hit our last two slides, and then we'll turn it back to Katie to wrap us up. Depending on what exactly we're issuing, we need to figure out what securities law exemptions we're relying on. For public companies, they register their shares on an S1 or a Form 10, the company shares, and then they register shares under the plan on what's called an S8. For private companies, we have to look for an exemption from the federal law and then also for the state law. Federal law is frequently what's referred to as Rule 701 that allows for compensatory benefit plans. And then a lot of state laws have a similar thing, but you have to look in all the states, and some of the requirements are different, particularly in California. And then our last slide here is corporate issues that you want to think about if implementing one of these plans. And I'll try and breeze through these quickly. Again, who has to approve this type of plan? In public company context, it has to go to a vote of the shareholders. In this context, you just need to think through who needs to do that under state law and under the bylaws of the company. How much equity should we give to the folks? And then once we're giving folks to the employees, should the company have these rights that are here on the slide in terms of the right to call we talked about? Can you purchase the shares back when an employee terminates from the organization? Should you have, if you're doing a sale, can you force the employee to sell their shares at what's called a drag-along right? And then also, if the employee owns their shares outright and wants to sell, should the company have a right of first refusal saying we can buy those shares? And then there's corresponding awards for issues for the recipient side. Should they have the ability to put their shares, sell them back to the company when they leave? Should they have a correlated to the drag-along right? Can I tag along with you? If you sell the company, can I come with and sell my shares at the same time? And then registration rights. If you're registering shares to sell, can I get my shares registered as well? So let me stop there for a second and see if Katie, if we had any questions come in. I know we're at time, so we can maybe follow up with the questions later if
we have a couple of questions. I think we can follow up directly with them. So okay. I thank you both.
Sure.
And I'd also like to thank all the guests for attending this symposium, as well as my colleagues at Winston and Strawn for co-hosting it. As you know, the symposium is an annual event, and so I hope to look forward to seeing many of you at next year's symposium. And I think Joe's going to sign off with the CLE information again.
I am, yeah. Let me join you, Katie, in thanking everyone for participating. We're delighted to do this with you, so thanks to you and the law school for doing it. Thanks to Don for the excellent presentation. That's always a pleasure to hear Don talk. And yeah, at this point, this is usually where we'd go for drinks at the bar right afterwards, Katie. When we had these things in person in prior years, so I'm sorry we can't be together for that this year. But everyone save your drink coupons. We'll use them next year. Yeah, so for the last administrative items on CLE, as a reminder, you were sent the email yesterday that has the link to the evaluation form. Complete the form to get if you want to get credit for CLE for today's presentation. Once again, that CLE number is 082520. 082520. And then as Steve mentioned, this presentation slides will be distributed in that email as well. They should be receiving that in a few days. And feel free to contact any of us if you have questions. Thanks so much.
Perfect panel.
Take care. Thank you.
Thank you.